For the list.
My lord,
He's
my
not
lord,
indeed, Mr.
my lord,
Hall.
might permitted to mention one extremely urgent matter, my lord.
I
Regarding
kindly recall that in respect of the School Service Commission matter, your Lordship Miller directed me that in respect of those particular persons whose examination will be held on 14th, you kindly mention in the next week.
What is the issue?
Issue is a very interesting issue. My name does not appear in the list of tainted candidates, nor my list. My name does not appear in any other list. Provisional admit card issued for appearing in the examination on 14th of September 2025. Then suddenly, without any reason, anything, they say that no, you are a tainted candidate.
And it has been decided by this court.
No, I say
In case of before 7th of September.
there are two dates.
Therefore, separately the matters cannot be decided.
Kindly consider one.
If you are not eligible or tainted, nothing can be done.
No, I say Miller only
go before the higher.
I have to go, Miller. I know
Yes,
that.
sorry.
But
second SLST, my lord, only
matter is running in the list. Miller, I say Miller, your lordship may pass the any.
No, that is not the. I have already decided the issue in case of 9, 10, and 11, 12.
9, 10, 11.
Yeah, 9, 10, 11, 12. So separately matters every day cannot be taken out in this fashion.
my lord,
I did. In Mase, we have passed order. Each and every day matters cannot be taken separately.
my lord,
Which one is your matters?
164.
Already issue has been decided. Already issue is decided. Right up to Supreme Court, it has been decided. After I passed order, it was tested before the division bench. Division bench did not interfere. Nothing remains. What remains?
May I say one thing?
Yes.
An appeal. I cannot say anything more. Let it appear under the head to be mentioned, pass the same order.
Well, tomorrow urgent motion.
Yes, we mentioned dispose of the
but second SLST 25th, 23rd, or my lord, the Sunday is the examination, my lord, only medium of vacancy. There was a mistake, my lord. Instead of Bengali, my lord, I have mentioned my English, my lord.
Tomorrow urgent motion.
Grateful.
my lord, my lord, might I be, my lord, might I be permitted to mention one extremely urgent matter, my lord?
Withdrawal of the writ
Mention on
petition.
Monday.
I had mentioned it on Monday. It was supposed to appear today under to be mentioned. However, it's not
Talk
appeared.
to my officer. Yes. Yes, call the list.
Under compelling
My lord,
allow me, my lord, the petition is a disabled person covered by the paragraph 48 and 49. Order passed by the Honorable Supreme Court in final order. In spite of that, his name has been included in the tainted list, but he will not be allowed.
I have decided the issue.
So he's a
No
disabled
further,
person.
nothing.
He will not
Maybe
be
disabled. If he is tainted.
No,
Nothing can be done.
disabled candidate has been protected.
Tomorrow
under-
urgent motion ওটার সঙ্গে দিয়ে দেবে.
Yes,
Same order is to be passed. Nothing.
Yes, your lordship.
No judicial adventurism.
Lordship,
Yes.
lordship.
The petitioner select the wrong language, whereby instead of Bengali, they select the English.
Yes.
Exactly.
How many matters are there? How long this will continue? I have allowed all the mentioning last week.
Only one matter, for 11 to only one. Kindly.
Who is appearing for the commission? Have you served notice? When you have filed it? When you have filed, who has served notice? How you have served notice? Yes, show me notice.
Right now, I have
Yes. Don't mention for the sake of mentioning. What steps you have taken? Ascertain and then mention at 2 p.m. Yes.
my lord,
So this petition, it has been served upon us.
Served upon you. Very well. Tomorrow urgent motion. Call the list.
my lord, this is an extremely urgent matter subject to your lordship's opinion, my lord.
On Monday.
My lord,
Listen until it is extremely urgent.
Item number
My
1.
lord,
Yes.
my lord,
Yes.
I'm grateful before your lordship. My lord, the petitioners are the untainted candidates in respect of the first SLST. Now, my lord, they are the teachers of commerce in respect of class 11 and 12. Now, my lord, this SLST, my lord, the SST has made an unjust division of the same subject, that is commerce, into accountancy and commerce. My lord, the petitioners are eligible to sit for both of the categories, yet they are being prevented, my lord. They tried to apply, my lord, for both of the categories because the syllabus are the same. But my lord, they have been prevented. They have not been allowed to appear for, your lordship knows, for both of the categories, my lord. That is the grievance, my lord.
Which
14th is the
category?
exam,
Both
my
of
lord.
the category means is not clear to me.
Commerce, accountancy and commerce. Commerce has been divided
See,
into
whether
accountancy and
accountancy
commerce.
is beyond commerce.
No,
Then
that is what astonishes the petitioner, my lord. But kindly, my lord, let the matter be heard.
so you have already
Kindly, my lord.
applied and you have admit card has been supplied to you.
I made several representations. I tried to apply on in both of the categories.
So in
But my
one
lord,
category you have applied.
yes, my lord, but petitioners have already suffered a lot,
So
my lord.
since one category you have applied, you sit in the examination and then court will consider later on. Yes.
My lord,
File the
kindly, my
matter,
lord,
indicate the date. Already admit card has been issued to you in under one category.
under one category,
Very good.
provisional admit card.
In that event, you participate and you indicate a date in your presentation form, it will appear. Yes.
So for my
I'm sorry. I apologize before your lordship. I
What is
couldn't
the
get.
agency?
agencies, my lord, in terms of the applications, my lord, order of the Supreme Court, those are they applied before the West Bengal Regional Staff Selection Committee for the holding 2, 7 and 14. Well, I have received the admit card on 7th, I have duly appeared. So far the 14 parties concerned, no admit card is issued. Only the plea that as they have considered only one examination, so 14 they are not issuing any admit card. Well, this is the difficult one. But in
So
terms of,
you have applied for 7th.
no, I have applied both. Because in terms of the undertaking before the Supreme Court, that the applications means stated to be both the examinations. Well, this is my only urge.
Applications stated to be both the examinations.
It is given under
Where, in which order Supreme Court has said?
Well, Lord,
Show me.
one second.
Yes.
Well, Lord, order dated 20.
Show me the order.
In page 4 and 5. Lordship. Last paragraph. Page 3. Last paragraph.
In at page 3.
Last paragraph and continuing.
Further process of selection shall not be treated as postponed.
So kindly turn the page 4.
Yes. Now you participated in
First,
the
7.
yes,
I
yes.
have received the admit card, I duly appear. But so far the 14th examination is concerned, my lord, I have not been provided any admit card. Only to appear.
You are entitled to appeal. Where is your entitlement?
My lord, I have applied because in terms of
No. You have applied in the
we
in
are-
terms of the recruitment notification dated 30th of May. Have you applied to participate in both the examinations?
No, my lord, so far the first, my lord, one second. So far the those appointment was already been, my lord, discontinued.
I am asking you a simple thing.
Lordship.
In terms of recruitment notification, have you applied for both the examinations? You have applied. In spite of that, admit card has not been issued to you.
So far the second examination is concerned. First part is given second party.
How many candidates are there?
Only three.
In one petition, you have filed, three have joined.
Well, because urgency, but I have no
Three
option.
have joined in one petition. Tomorrow, urgent motion.
Can you leave me?
Serve notice upon the other side.
Lord.
He is appearing for the commission. Serve notice upon.
Lord. Okay.
My lord, if my matter,
Please call the
your
list.
lordship, my lord, if your lordship would
Item
be,
number 1.
please to keep the matter tomorrow, my lord.
Monday, my lord,
My matter.
I mentioned the matter, my lord, where my lord petitioner was allotted 0 in physics theory, my lord. My lord, after mentioning, my lord, I have served notice to all the.
So you want to withdraw?
My lord,
You want to withdraw? I remember. That's why I have directed the matter to appear in the list under the heading to be mentioned. So don't open your case in this fashion. Yes.
My lord, my
Regarding
matter, if
withdrawal,
my
what
matter-
is your submission?
regarding withdrawal, my lord, I have made a prayer for review, my lord. They have intimated me, my lord, the open school NIOS intimated me to participate in the supplementary examination, which will be held in the month of October 2025. So, my lord, unless, my lord,
Issue. Matter has come up in the list under the heading to be mentioned on being mentioned by the learned advocate representing the petitioner. Next paragraph. The learned advocate representing the petitioner submits on instruction that petitioner does not want to proceed with the matter. Stop. Respondents are represented by learned advocates. Next paragraph. In view of aforesaid submission, writ petition stands dismissed as withdrawn. Stop. The parties to act on the server copy. Deeply opposed.
My lord,
Next.
my lord, if your lordship would be pleased to keep the matter tomorrow, my lord.
Item number 2. But I appear for the
But I am appearing for
Yes,
the,
lord.
but petitioner intends to appear in the second SLST 2025 for the posts of assistant teacher in classes 11 and 12, my lord. And petitioner intends to appear in the second SLST 2025 for classes, my lord, 11 and 12, my lord.
Yes.
My lord, in the online application, my lord, page 30, my lord, the against the column, my lord, subject applied for, my lord, instead of English, my lord, the petitioner has mentioned, my lord, inadvertently Bengali.
Same issue.
My lord, it's not the same.
no, my lord, this is not possible.
I
My
have
lord, today,
decided already.
my lord, I am just, my lord, it is very difficult now, my lord. Today is the Wednesday, it is very difficult.
But
Lord,
last occasion I passed an order, Mr. Bandyopadhyay.
My lord,
Just
that is
before
on
7.
kindly excuse, just excuse me. Just excuse me. But that is on Monday. Now all answer scripts have been sent. He is at Jalpaiguri. He is at Jalpaiguri. He has made the application.
Question papers have been sent.
My lord, question paper sent. My lord, center has been indicated.
Where is your application?
My lord, page 30, my lord.
Page 13.
30, my lord.
30. 31.
3, my lord.
30.
30, my lord.
My lord, it is subject English to subject Bengali. It's not the medium.
No, subject applied for. My lord, instead of Bengali, it will be, my lord, English, my lord.
Bengali language studies.
Subject,
Which part of this
my lord,
application? you have-
subject applied for.
Subject applied for English PG. It should
Ben-
be
Bengali-
Bengali PG. Bengali
It should be,
PG.
my lord, English.
English.
My lord, I have got, my lord, postgraduate degree in English, my lord.
Mr.
My
Bandyopadhyay.
lord, kindly come to page 38.
Mr. Bandyopadhyay. Be human.
Ajay, can I suggest one thing? Can I
Yes.
suggest? My
It's
lord,
a
let
battle
him-
between lamb and lion.
No, let him come. My lord, it is not possible to send the question. What I am suggesting, let him come to SSC head office. He will give the examination there.
Immediately?
Let him come to SSC office at Salt Lake, and he will give examination there.
From there.
Otherwise, I can't make anything, any arrangement. Let him come. I am.
Yes,
Very well. Very well.
yes, I am.
Whether the petitioner is ready to attend the office of School Service Commission for participating for writing examinations.
Otherwise, I will in difficult. Yes.
Very well. Since you are making this submission, but I will record your submission and give direction. That
Yes,
she will.
yes.
So then the commission office will be converted into an examination center.
But we will make another arrangement there. Because I can't make any arrangement to any center now. Today is Wednesday. And he has made the application after 1 month, 2 months, 20 days. Correction is
It
after 2
appears
months.
that it appears that it's a bona fide mistake. Why I'm telling you
No, bona
that
fide mistake.
he is having qualification of PG in English, but at a time of submitting online application, it is stated Bengali PG.
Had I committed this fault, in a format, the residuary group to do this group, your losses will not allow me to do it.
Who says so?
You are so strict.
No.
No, in that matter, in one of my matter, it said no, then it will come under that primary category, not higher secondary category.
It's a question of examining.
No, kindly see, when he has
It's a question of a candidate.
My lord, I am not
a candidate, Mr. Bandyopadhyay.
My lord, am I not hearing to your lordship's
Yes, since you are there, take steps.
No, I am saying
where petitioner stays.
But Kuch Bihar.
Bihar.
Otherwise, my lord, I will be. She will come.
From Kuch Bihar, she will come down to Kolkata.
Otherwise, I can't send it to the question now. Question papers have gone.
There is a regional commission at Malda. So then I can direct that, that she will attend the office of regional commission Malda and write examination.
No, Malda, that is no arrangement. My lord, kindly see, my lord, kindly do not, my lord. Kindly tell him to come. Today 10, tomorrow morning they will come.
This is easy for an MP.
Not for an MP. Easy for everyone.
Normal citizen.
Everyone, let him purchase ticket. I will get it.
What is very usual for you, it is not usual for others.
No, everyone, let him purchase ticket and give the
See the problem from the angle of a common people.
No, common people, I am helping. Let him purchase the ticket. And I will see that this is confirmation has been made.
Ticket. First of all, there's a problem. When we sit, when we are on circuit at Jalpaiguri, most of our support staff don't, their tickets are not confirmed. We find regularly.
They can come by the bus, my lord. They can come by the bus, my lord. The bus is available.
If it is the problem of High Court, then what would be the...
No, that I cannot say. High Court has never sought any assistance from me. Otherwise, I could have seen that.
Yes.
My lord, the bus services are very good, my lord. Let them come by the bus.
Allow her.
Allow when?
Allow her at her examination at a center.
This is not possible, madam. This is really not possible.
She will
kindly record that this is not
be
possible.
changed, my lord. There's administrative difficulty.
Kindly record that, this is not possible, Miller. Kindly record my submission.
Yes.
And I have given an alternative submission. Kindly record that and thereafter, my lord, whatever your lordship pleases.
Yes, sir. Affidavit of service filed on behalf of the petitioner is taken on record. Next one. Petitioner applied and a petitioner submitted application in terms of recruitment notification dated 30 May 2020. Miss Bandyopadhyay, do you have a copy of the order? Similar order I have.
Yes, but yes,
yes.
Medium change order.
That perhaps is a medium change.
Yes, that I have no
separate question paper.
It's a change of medium, it is a change of subject.
My lord.
New separate question paper.
কি বলছিলাম?
Paper do like
2025. Being memo number 1092/7016/CSSC/ESTT/2025, page 70. Sentence টা বলো। Transfer. So inadvertently in the online application form it was submitted by the petitioner. against subject applied for, quote unquote. Petitioner stated Bengali within bracket PG, P capital, G capital, instead of English PG. And based on which admit card was supplied to the petitioner, treating her as Bengali within bracket PG candidate, not English. The petitioner, by instituting this writ petition, has prayed for direction which would permit her to participate in the ensuing written test scheduled on 14th September 2025 as English within bracket PG candidate. Stop. It is submitted on behalf of the petitioner that by mistake. Next one. Prayer made by the petitioner is opposed by Mr. Kullan Bandyopadhyay, and senior advocate representing West Bengal Central School Service Commission, who appears in virtual mode. Stop. It is submitted on behalf of Commission that that just before written examination scheduled on 14th September 2025, if Commission is directed to treat the petitioner as English PG candidate, that would create difficulty in organizing the events, or in organizing or that would create difficulty in complying necessary formalities, thereby permitting the petitioner to participate in the ensuing examination by treating her as English PG candidate.
Another one ground that kindly, another argument, Millard, kindly just record, Millard. He has made the representation almost after 2 months for correction. That is at page 38.
Page 38.
Right. And 20 days after issuance of the admit card.
It is also contained that representation was made by the petitioner on 3rd September 2025 by sending email letter to the secretary of the commission, which is much after submitting application in online submitting application in online mode.
And 20 days after the issuance of the admit card.
Therefore, according to the commission, at this belated stage, prayer of the petitioner may not be permitted. Next slide. Having considered the respective submissions made on behalf of the parties, it appears that selection process has been initiated by the West Bengal Central School Service Commission after a long period of time. And petitioner being unemployed youth got the opportunity to make application online, offering her candidature for participation in written test scheduled on 14th September 2024. So, on perusal of the materials available on record, it appears that due to inadvertence at the time of submitting online application, petitioner described herself being an Bengali, petitioner stated, described herself, petitioner stated that she should be treated as a candidate under Bengali PG. Under the subject Bengali PG, under the subject Bengali PG. Though petitioner is having or petitioner is possessing postgraduate qualification in English. Stop. Such fact goes to show that there was bona fide mistakes on the part of the petitioner in submitting online application for offering candidature under the subject. Now, while offering candidature under the subject English PG, stop. Albeit submission has been made by Mr. Bandyopadhyay representing commission that petitioner may be that arrangement can be made for the petitioner to write examination by attending office of West Bengal Central School Service Commission at Salt Lake in Kolkata on the scheduled date, that is 14 September 2025. But it appears that petitioner stays at Kuch Bihar, which is far away from Kolkata, and at this stage, if petitioner is compelled to attend the office of West Bengal Central School Service Commission for writing examination, that would create difficulty so far petitioner is concerned. Now, that would create hindrance so far petitioner is concerned. Stop. Taking note, next paragraph. Taking note of the aforesaid aspect, concerned authority of the West Bengal Central School Service Commission is directed to permit the petitioner to participate in written examination scheduled on 14 September 2025 by treating her as a candidate under the subject English PG, not Bengali PG. And an admit card is to be issued in favor of the petitioner by September 2025. And a fresh admit card to be issued. Next paragraph. Client advocate for the petitioner is granted leave to communicate this order without waiting for server copy of this order upon the West Bengal Central School Service Commission in course of this day. Stop. You also communicate. Mr. Bandyopadhyay, I have recorded your submission.
Yes.
Writ petition stands disposed of urgent xerox. Parties to act on the server copy. Yes, yes.
At Kuch Bihar, we do not know how we will send the questions. That is the whole difficulty. Otherwise, we have seen that earlier. I have said yes to it.
Since you are there, court believes that an appropriate arrangement can be made.
Yes. Yes.
Yes, next.
Item number 3. Your Lordship, in item number 3, I appear for the state. Your Lordship, we haven't received the copy of the vacancy. Yes, no. What did you say?
Yes, what is the matter?
The incremental benefit which was given earlier.
Retrial benefits.
Yes, madam, after.
It has been released.
No, no. Entire dues have been declared. Now that this incremental benefit which was given, that was directed, that was also have been given within a 5 years. It is given within 5 years, 1 month.
Within 5 years?
1 month, within 1 year, 1
The
month.
delay is 1 month period.
Your Lordship knows that within a 5 years, if I do not have the GNP, I have to complete within a period of 5 years from the date of birth.
Yes.
So I joined the schools in the year of 1980. In 1993, I completed, I was deputy cabinet. And within 1 year, classes were completed, but the examination was given. The examination held, and thereafter certificate was given. Examination result was not published due to inaction of the Calcutta University. There was 1 month, 3 or 4 days delay was. That's why they said we have not completed 24 days. We have not completed within a period of 5 years. To show it should not be incremental benefit. That was wrong.
You retired on 31st January 2025.
I retired 31st January.
From the post of assistant teacher.
Yes, and objection was raised, page 33. Page 33.
Yes, page 33.
33, your Lordship's kindly consider. The increment will stop from 1st July 1993 due to untrained and will start again on 25/8/2093, that is after completion of the BA. Hence, pay should be recovered in part D and serial number 8 onwards, and overdrawn to be calculated and deposited to absolute service. Then, madam, they have filed a report. And your Lordship recorded everything. Your Lordship ordered it to enter.
Just a minute. Start again on 20th August. But the stand in taken in the report. It is reported at 7th August 2025.
Yes.
Just. Show me this this ROPA 90 .4 paragraph 6. That is the relevant provision. Point 4 of paragraph 1633 DNB.
The report it has been annexed.
But the relevant provision, that is clause 4 of paragraph 16, it says that those who will be appointed on or after 1st of January 86, here petitioner was appointed on 1st of July 1988, So those who will be appointed on or after 1st of January 1986 within 5 years from the date of appointment, failing which increment will be stopped till they get themselves trained. So admittedly, you did not obtain training qualification within 5 years. You enjoyed 4 years increment for a period of 4 years. Fifth year, when you could not obtain training, then government is saying no. Fifth year, you are not entitled to get the increment, but after obtaining training, you will get increment. What is the wrong in it?
I tell you that
But the refund which has been calculated, that you cannot that is not recoverable from you in view of paragraph 18 of Rafiq Master. But so far the fixation of your pay, it has to be on the basis of the methodology which has been indicated in the relevant document.
Two-fold submission I made. Firstly, I initially joined a school that is in the year of 88. After tendering resignations after further selection process in 89, I joined this registration. 89, initial appointment only, if your lordships kindly have to look, if it is taken into consideration 89, then my lord, this within 93, 94, I'm getting that. If the 89 is taken into consideration.
No, 1st of July 1988 is your first date of appointment. Thereafter, you change the school.
Yes.
Your first appointment is in Ushangini Balika Vidyalaya
Yes.
on 1st of July 1988. After that, but you retired from Shalkia KBR Girls High School, Howrah. Now, question is was there any break of service? Break in service? No. So, therefore, your first appointment is to be reckoned from 1st of July 1988.
The rule says if I'm taking the
Mr. Bari, I will direct that let the admissible dues, admissible benefits be paid to the petitioner, and your fixation of pay, fixation of pension will be decided finally on exchange of affidavits. But that payment which is to be made without insisting upon the petitioner to refund them. Because yes,
release the
whatever is due,
yes,
or whatever is found to be excessed on, that cannot be refunded at this stage in view of the ratio of Rafiq Master. So the admissible dues may be paid, but fixation of your pension, so far grant of incremental benefit, that has a bearing on fixation of your pension, fixation of your pension.
Lordship kindly pass me.
Issue. Affidavit of exception filed on behalf of the petitioner is taken on record. Stop. Petitioner was an assistant teacher who retired on superannuation on 31st January 2025. Stop. It is submitted by the learned advocate representing the petitioner that till date, retirement dues, including pension, have not been settled in her favor. However, Provident Fund dues have been cleared. Stop. It is also contended in reference to a document at page 33 of the writ petition that objection was raised by the
Observation raised by joint letter.
yes. Joint Director of Accounts, Office of the District Inspector of Schools, AC Howrah, regarding sanction of incremental benefits from 1st July 1993, which petitioner availed. Though on 1st July 1993, petitioner, though within 1st July 1993, petitioner could not complete or petitioner could not obtain B.Ed qualification. Stop. Since petitioner obtained B.Ed training, B.Ed qualification on 25th August 1993, increment ought to be increment could have been allowed to the petitioner. Increment was required to be allowed to the petitioner from 25th August 1993. So for 5th year of petitioner service. না কি বললাম সেন্টেন্সটা? বাকিটা কেটে 25th August 1993. Stop. Next paragraph, by filing a report respondent number 3 has disclosed that while processing pension case, rupees 391,104 was calculated as exception amount, which is relatable to sanction of yearly increment from 1st July 1993, which petitioner was not entitled to prior to 25th September 25th August 1993. Next paragraph. Whether petitioner is entitled to receive, whether petitioner was rightly sanctioned increment from 1st July 1993 or not has a bearing on fixation of pension of the petitioner, on her superannuation, on 31st January 2025. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 2 weeks after ensuing pujafication. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. State respondents are directed to file. Next paragraph. Petitioner shall be at leave to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. In the meantime, state respondents are directed to release admissible retirement dues, including pension, to the petitioner by 4 weeks from the date of communication of the sum, without insisting upon the petitioner to refund the excess drawn amount as indicated in the report dated 7th August 2025. Next. Item number 4.
Sir, I am appearing on behalf of respondent number 8 to 10.
At least is one 13th of August order once.
Yes.
So that covers one at every.
ওরা দিয়েছে তো সাপ্লিমেন্টারি ওরা দিয়েছে
এই তো ম্যাডামকে দিয়েছে।
Supplementary affidavit?
Yes. This is 13th of August. But that was the first order matter that August one is excluded from the entire matter.
Yes, which is the period?
But virtually I have mentioned. So equals to not to see, which are available to see.
দিয়েছে।
Paragraph number 6.
চার্জশিটের পরে নেই। চার্জশিটের তারিখটা
So your grievance is this 100 days leave, as you have indicated in paragraph 6 of your supplementary affidavit, is treated as unauthorized leave. So where is the memo of the
I say that this issue is already decided.
just a minute, this is 2nd April 2025.
Yes.
So memo issued by the school authority.
105.
Just a minute.
105 page নাম্বার নাকি? বলেনি।
এটা বলা আছে।
Now that is one of the charges which has based on which disciplinary proceeding was initiated against you. Yes, how school authority can do it?
What happened? My lord, the impugned notice dated 2nd of April 2025, page 159. My lord, kindly sees, it is stated as the last line, these periods of unauthorized leave will be recorded accordingly. And my lord, I have given copy to the Honorable President of West Bengal Board of Secondary Education and Honorable DI of Schools of Secondary Education, Hooghly. Why I have sent this notice, my lord, kindly comes to page 151. This notice has been given to me, and the last line it is stated for your information and taking necessary action. So, my lord, I have only intimated her. That's all. And I have given copy to the president also, to the DI also. এইটার জন্যই আমাকে চিঠিটা দিয়েছিল, তো দিতাম না হয়তো। I thought, my lord, that
just
my lord, sorry, my lord.
This is a communication of charge sheet.
এইটা দেখ না, এই পেজ
It's a
151
communication of the final order.
ফাইনাল অর্ডার। ওরা তো আমাকে বলছে ইনক্লুড
Necessary action মানে
হ্যাঁ,
তার
necessary
মানে
action মানে আমি
কিছু
ভেবেছি কিছু একটা করতে বলছে।
আবার হয় নাকি? ভাবি
এটুকুই আমি বলছি, আমি শুধু I have only intimated.
ভালো বলেছে, আমি ভেবেছি।
আমাদের সেই ইনস্ট্রাকশন।
Yes,
But once a final order is passed in the disciplinary proceedings, this you cannot do.
well, this is just a communication of the final order, my lord. The final order.
Final order is at page 153.
Yes, and this is a communication of the final order to the concerned school, which my learned friend is showing. But 151, nothing.
How your school can do this?
My lord,
going beyond the scope of the order of punishment that the petitioner.
At the same time, I have informed the DI and president also, my lord,
Because the school authority is not authorized to do this.
My lord.
Whatever, come to the charge sheet, page 105. Page 105 for July 2024. Then charge number 2, that allegedly she has enjoyed several periods of unauthorized leave, including CCL. So this was one of the issues before the disciplinary authority.
And thereafter she
And the
was censured.
outcome is page 153, that petitioner to be censured. So if you are agreed by this order, you could have challenged it. But the school authority cannot sit in appeal over the decision of the disciplinary authority.
My lord.
So this cannot,
My lord, only
this cannot retain with the records.
due to the letter which has been annexed in page 151, I have given that
No,
letter.
this is
But
just
there is no
information.
indication in the letter, Mr. Chattopadhyay.
My lord, it is stated for your
It's a mere
information and
punishment
taking necessary action.
order after taking the disciplinary proceedings to its logical conclusion.
Yes.
So can it be tinkered with in this fashion by the school authority? Answer is no. There is no statutory provision. Issue. In terms of the order dated 19th August 2025, a supplementary affidavit is filed by the petitioner and same is taken on record. Next paragraph. On perusal of paragraph 6 of the supplementary affidavit, it appears in tabular form. Details of periods and dates on which petitioner could not attend the school are given. And according to the petitioner, those periods and dates ought to be treated as leave. In terms of paragraph 6 of supplementary affidavit, last period when petitioner did not attend the school was from 22nd January 2023 to 26th January 2023, and which according to the petitioner was availed of as child care leave. Next paragraph. It needs to be recorded hearing that based on certain allegations, disciplinary proceeding was initiated by the concerned authority of the West Bengal Board of Secondary Education, within bracket for short board, and a charge sheet was issued on 4th July 2024. One of the charges leveled against the petitioner was enjoying several periods of unauthorized leave, including child care leave, within bracket CCL. Considering the periods of leave availed by the petitioner as indicated in paragraph 6 of the supplementary affidavit, and the date of charge sheet which was issued on and the charge sheet which was issued on 4th July 2024, it can be inferred that the periods which are indicated in paragraph 6 of the supplementary affidavit was one of the issues. It can be inferred. তারপর কি বললাম বলো তো? Now, the periods availed of by the petitioner as leave/childcare leave was one of the issues before the disciplinary authority. Stop. It further appears that disciplinary proceeding which was initiated against the petitioner in next paragraph. It further appears that disciplinary proceeding which was initiated against the petitioner was taken to logical conclusion and final order was passed on 11th March 2025 by the President, ad hoc committee of the board. Thereby, petitioner was warned that the repetition of 10 offenses would attract strict repetitions of same misconduct would attract misconduct would attract strict action as per rules and it was expected and it was expressed that petitioner would work in greater interests of the students and the institution. Stop. Next paragraph. Therefore, what emanates from final order dated 11th March 2025 passed by the President of the Board, the issues based on which disciplinary proceeding was initiated, including leave/child care leave availed of by the petitioner, was put to rest. Stop. Next paragraph. However, authorities of Horipal Tirthobashi Girls High School, Hooghly, even after final order was passed by the President of the Board on conclusion of disciplinary proceeding on 11th March 2025, issued memo dated 2nd April 2025, thereby intimating the petitioner, thereby it was intimated to the petitioner that 100 days that unsanctioned leave, that leave availed by the petitioner aggregating 100 days to be treated as unauthorized leave as per decision of the managing committee of the said school dated 29th March 2025, and same to be recorded in the service records of the petitioner. Next paragraph. After conclusion of disciplinary proceeding, culminated into order dated 11th March 2025 passed by the President of the Board. Thereby petitioner was warned said school authority is not authorized to pass separate order in connection with leave availed of by the petitioner, which was considered by the disciplinary authority by issuing charge sheet dated 4th July 2024. Stop. It is apparent from the materials available before this court today that last stretch of childcare leave was availed of was from 2nd January 2023 to 26th January 2023, whereas charge sheet was issued on 4th July 2024, which goes to show that the periods indicated in paragraph 6 of the supplementary affidavit was taken in which goes to show that periods availed of by the petitioner as leave / childcare leave was taken into consideration by the disciplinary authority while initiating proceeding against her. Next paragraph. Hence, memo dated 2nd April 2025 issued by the said school authority declaring the said period of leave within bracket 100 days as unauthorized, comma, stands set aside. Stop. However, said school authorities shall also be at leave to take decision in terms of the relevant provisions of leave rules LR capital. If further leave availed of by the petitioner beyond the periods as mentioned in paragraph 6 of the supplementary. No. Writ petition stands disposed of by the xerox.
37. I have mentioned that I did not take any.
But don't misuse
Absolutely.
the order passed by the board as well as this court today.
Absolutely.
And go on taking leave.
Absolutely.
Because court knows that these are the persons who are habitual absentees.
But,
Yes.
great.
Item number 5.
This is Melody. Yes, Melody, retired from service.
Just a minute, I have passed an order. Let me go through this one. Yes.
Second page is the report of the Joint Director of Accounts.
Just a minute.
Highly consider only 5.
Why Assistant Director of Accounts has prepared the report?
That is why I am submitting kindly don't
Whether your joint director is above code?
Oh, joint director.
Yes.
Joint director. Or is the joint director?
Who was director number 4?
Joint director.
So how Assistant Director has prepared report? Come to the first page of your bunch of documents which you are.
This has been referred.
Please come to the first page. Read it, Mr. Chattopadhyay.
Report of the question number 4. The Joint Director of Accounts, School Education Department, Secondary Education, such and such. And signature also given by
A report dated 26th August. A report dated 26th August 2025 of the Assistant Director of Accounts, School Education Department, Howrah, in favor of respondent number 4. In favor of a Joint Director of Accounts, School Education Department, having office at 18 so and so, is hereby submitted in the matter. So a report dated 26th August of the Assistant Director. Please turn to next page. 26th August 2025.
Yes.
Submitted by respondent number 4 for the Joint Director of Accounts, School Education Department, for the Joint Director of Accounts, School Education Department, Secondary Education, so and so. Then Assistant Director of Accounts.
Yes, I have seen
it. When Commissioner of School Education is filing report, Joint Director of your JDA is so high in the rank that he will not comply with the order of this court. That for him, Assistant Director will submit a report.
But I have communicated my lord's order to the District Inspector of School. District Inspector of School in his turn communicated the order to the.
Yes, I am not saying anything, but you are also representing JDA. District Inspector of School is not at fault.
The rubber stamp of Assistant Director of Accounts.
Yes.
Yes.
How Assistant Director of Accounts is coming into the picture? I have not directed him to do anything.
Kindly excuse it because petitioner is entitled. I have seen the report. I am not also satisfied with it. I am not myself is satisfied.
Ask your JDA to submit a report.
This issue has already been decided by the Senate.
Issue. In terms of the order dated 19th August 2025, Joint Director of Accounts, School Education Department, Howrah. School Education Department, Secondary Education, Howrah was directed to submit a report. But surprisingly, from the memo dated 1st September 2025 and report dated 26th August 2025, it appears that report was not prepared by Joint Director of Accounts, but by the Assistant Director of Accounts. Stop. Memo dated Next paragraph. Memo dated 1st September 2025 issued by the District Inspector of Schools in bracket AC Howrah, enclosing report of Assistant Director of Accounts, School Education Department, Howrah, dated 26th August 2025, is taken on record. 7 days time is given to Joint Director of Accounts কেটে দাও 7 days time কিন্তু জন hearing of this matter stands adjourned for 7 days for granting opportunity to Joint Director of Accounts, School Education Department, Secondary Education, Howrah, being response number 4, to file report strictly in terms of the order dated 19th August 2025, failing which an appropriate order is to be passed on the next date. Next paragraph. List the matter under the same heading for further consideration on 18th September 2025. Tell your JDA to file a report. Otherwise, you will face music.
Item number 6.
Have you served notice upon the school authority?
27th of August, not the receipt.
Whether anybody is representing the school authority?
I'm the commission. Wait, what?
Hey, just a minute. ছিল এসএসসি চেষ্টা করতে একটা সাইক্লিস্ট মার্কেট লিস্টটা সেটা এখন তার motion. Yes, now the school is not representing. We are for the state, and for the commission. Is there a transfer on medical ground?
Medical ground of myself. But
What is your instruction? Where the transfer application is lying?
I tell you, it is since the online application got suspended from September, it is there before the school online way. Now, my lord, what happened here? I made deputed letters to commission as well as the district inspector. Then the district inspector says that since it is the portal is suspended, so it cannot be taken care of.
DI is saying.
DI said. So that order, my lord, I have also annexed in the writ petition. So effectively, my lord, the application is lying before the school only, and it is not even the medical verification is also not done. My lord, if I request your lordship to see only once.
But why you are coming after such a long time?
My lord, because
it's an application made in the month of April 2022.
But I was waiting, my lord, for the portal to be reopened because each 6 months they were saying.
So file an application in the prescribed pro forma.
But if I could.
I am granting you only disposing of this petition. It's an old application. File an application.
I've stated in my affidavit, my lord, that the reason of my.
What is the reason?
The only reason that I just said before your lordship that each 6 months, my lord, I have been.
That is not a reason.
We said
referring representations or extending the time of suspension of portal is not a ground.
I just said
if you have made an application, you could have come on the next date.
The school teachers did not want to come before you this honorable court. They thought that it could be done.
School is not represented. Application is not lying before the DI.
It's not.
So file an application, April.
I do that. I do that. But if it could be subject to your lordship's kind consent, may I suggest?
Whether BMH verification was
Nothing,
made,
Nothing.
then
That is my grievance as well. The school kept it pending since then. I wrote to the
problem is Mr. Dhol and Mr. Bandopadhyay. If court grants liberty to the petitioner to file an application, the petitioner can make an application in prescribed pro forma. Again, petitioner has to come.
Yes, madam.
For getting a direction upon the school authority to forward it.
Yes. That is the difficulty, my lord.
The main
The subject to correction is also may pass order, my lord, directing if she makes such application, that will be considered in accordance with law.
So that
Because my lord, this is a medical on medical ground. No, my lord, from the annexure,
self medical ground.
Yes.
self medical ground, my lord, the page 18. But the problem is, my lord, the
Very well, let me direct the school authority to forward it to the DI and DI will obtain the report.
if it is my lord found that I am not eligible, I am not eligible.
Second application filed
page.
on behalf of the petitioner is taken on record. Stop. In spite of service of notice, have you, when you have effected notice upon
But 27th August they received.
in spite of service of notice, Helen Sharodamoni Balika Vidyalaya within bracket HS close bracket Hooghly being respondent number 6 to 8 are not represented. Or এটাকে এইভাবে করো, in spite of serving repeated notices. In spite of serving repeated notices. Next part. Petitioner made an application for transfer on portal on 12th April.
But it would be 5th of May 2022.
No, 6th of May 2022. Oh, last application.
last application.
6th of May 2022.
Previous application was
Petitioner made an application for transfer on portal on 6th May 2022
না যেখানে ছিল সেখানে there is no vacancy
on medical ground. And grievance of the petitioner is till date. State school authority has not forwarded the transfer application of the petitioner to the district inspector of school, to the concerned district inspector of schools AC Hooghly being respondent number 5. As a result whereof, transfer application of the petitioner is yet to be decided by the West Bengal Central School Service Commission. Next one. Headmistress of state school, headmistress of state school being respondent number 7 expected to forward transfer application of the petitioner in offline mode to the respondent number 5 by 7 days from the date of communication of this order. Stop. On receipt of transfer application, respondent number 5 shall obtain medical report on medical examination of the petitioner, or shall obtain report on medical examination of the petitioner, 2 or medical corona, medical examination of the petitioner by 4 weeks from the date of by 4 weeks from the date of receiving transfer application from the school authority, from the concerned chief medical officer of health / medical board. Next one. No, stop. In the medical report, CMH / medical board is required to opine, considering present health condition of the petitioner, whether petitioner is required to avoid long distance journey or not. Stop. If medical report justifies transfer of the petitioner, transfer application along with medical report shall be forwarded to the Chairman, West Bengal Central School Service Commission for taking decision. Stop. Chairman, Central School Service Commission being respondent number 2 for taking decision. Stop. On receipt of transfer application and medical report, respondent number 2 shall decide the same in accordance with law by 4 weeks thereafter. Stop. The decision to be taken by respondent number 2 shall be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear the suspension of portal shall not be a ground to reject transfer application of the petition. Stop. Writ petition stands disposed of urgently.
Great.
Lordship, I'm appearing for the state with Mr. Dole. I'm assisting Mr. Dole.
Yes. এই নামটা দিয়ে দিও। Next.
Great.
Item number 7.
You are preparing for the petition. The on record advocate Bhavini Mukherjee is suffering from jaundice. I am praying for 1 week accommodation, Your Lordship.
At the time of call, accommodation is prayed for on behalf of the petitioner, since learned advocate is unwell. Next paragraph. However, state respondents are represented by learned advocate. Next paragraph. List the matter under the same unlist the matter under the heading motion in the monthly combined list of November 2025. Next.
Item number 8.
Yeah. মালদাটা কোথায় আছে এখানে যেটা বের করেছিল ওটা বের করে
Yes, Mr. Bush.
The vacancy lordship is
Available.
one vacancy lordship here lordship, one vacancy lordship normal section and lordship one vacancy high. Kindly see lord.
Yes. Give a copy to him.
Yes.
You are a teacher of which subject, and whether you are teacher of a normal section or higher secondary section? Who is for the commission? Whether petitioner is a teacher of normal section or higher secondary section? That you do not know. File supplementary affidavit come in the month of December. Whether she is working in normal section or higher secondary section. She may be honors, maybe PG, maybe PhD. Normal. Then in Malda Railway Girls High School, one vacancy exists in normal section, but higher secondary section not available. UCB High School not available, normal section. So you have to be transferred to normal section, not in the higher secondary section. So if you are to be transferred to the normal section, then Malda Railway Girls High School petitioner can be accommodated, Mr. Bush.
Yes. As per the lordship directed vacancy, I am lordship.
Yes.
As per the
One
lordship,
vacancy exists in normal section.
therefore lordship pass the order. Lordship, I am giving you.
Yes. Where is the commission?
No, my lord, may I submit on?
Yes.
This was my lord the cancer case. My lord was pleased to direct the DI to file a report after obtaining.
No, I have not directed it to file a report. I have already directed. Now tell me that whether you are willing to, because I have recorded that you are willing to go to a second or third preference school.
That is the my lord, probably my lord, my submission was not there. The 2 schools, 3.
It was recorded in the previous order dated 3rd September 2025.
Recorded the record that the.
So therefore you are not willing. Say so.
First school, my lord, then.
First school is not possible, that vacancy is not live.
Prior to that, my lord, DI has reported. The second SLST notification was issued on, my lord, the 23rd, 30th May 2025.
In terms of the order dated 3rd September 2025, Mr. Bhaskar Prasad Boisho, learned additional government pleader, files a memo dated 10 September 2025 disclosing
May I interfere?
availability of vacancy in Malda UCB High School within bracket HS and Railway Girls High School. Yes.
There are two schools.
Malda and Malda UCB.
Malda Railway School, this is the third paper.
Hmm.
Malda UCB, Malda UCB, this is the second paper.
Yes.
If the petitioners hold, my lord, the postgraduate degree, she is entitled to, my lord, the second paper in her analysis.
That I do not know. What is the system? What is norms that the commission can apprise this?
Now, I want, my lord, the second preference.
But second preference school in normal section, no vacancies available. Then I have to hear the commission.
Higher secondary schools.
Not today.
Not today. You also just have to take instructions. The holds, my lord, the postgraduate degree.
You want to take instruction?
Only, my lord, the one.
Very
What
good.
is
একটা তাহলে order করে দাও। বলো না কি বলছিলাম বলো না, ঠিক আছে। এইটা তুই ঠিকঠাক কাজ করছিস। Next paragraph. Mr. Jana, learned advocate representing the petitioner, prays for accommodation to obtain instructions. Next paragraph. List the matter under the same heading for further consideration. On 28 October 2025.
But 8, my lord, you should posted on 28th October.
Yes, yes.
Well, 1 day accommodation I paid for. He's the cancer patient. Well, my lord, I have to instruction, my lord, from my client, third or second. Third, your lordship, I am willing to third or second. Well, just now I am.
Now, just
I
before
want
vacation,
no, I
further.
want it.
Whoever prays for time, it will be.
No, I
paid after.
1 day accommodation to take instruction. You also 28th October after vacation. You also
Yes.
a cancer patient. You also, my lord, please to date.
When application was made for transfer?
No, 25. 25.
What can be done? You are not in a position to.
Just now I have been handed over a report. Second or third, my lord, just my lord, what is my, I have to take. Kindly, my lord, next week I will inform to all others. My lord, kindly. See the my lord, I have two instruction. My client also is willing to accept third. My lord, I have kindly. Mr. Boshio is also my lord.
18th করে দিও তো ওটা ইয়েকে রণজিৎ ছিল নাকি
রণজিৎ ছিল বলে দিচ্ছি
বলে দাও 18
লাস্ট অর্ডারটা 8 নম্বর আইটেম 18 তারিখ
কল দি লিস্ট
আইটেম নাম্বার 9
ওয়ার্কিং
This is my lord. Page 35 is the representation.
First paragraph is not written.
And then my lord, page 35 is the representation.
আঠাশ দশ হয়েছে ওটা 18 10 8 নম্বর আইটেম 17,616 25 17,616 দাম দেখি 18 নয়
Page 35.
35.
Item number 10.
State File a affidavit service.
কনসিডারে পাঠালে কোনো দরকার নেই। কনসিডারে না পাঠালে ভালো।
35.
Yes.
19 June 2025 representation.
Yes, my.
July, August, June. Half.
The headmistress.
Yes.
Disposed of.
Yes, sir. Service take order. Item number 11.
My lord, in this matter, Joint Secretary passed this order, page 46.
You are praying for same order.
Yes.
Yes.
Page 46, kindly see.
That has been set aside by the honorable by a coordinate bench. Issue is no more res integra. Read the judgment of Subir Ghosh. Yes, both the judgments I have referred to in my order, which I am passing. Your representation, page 35. 7 July.
7 July.
Already issue has been decided. In Shubir Kumar Ghosh, this is, I have stated in my order, WPS 6217 of 2020. Disposed of. Petitioner is working.
Yes.
Item number 12.
The petitioner is an approved assistant teacher, was appointed in 2001. He applied through HOC for transfer. That is pending with the School Service Commission, page 21. That's the history sheet. Page 21, serial number 3, that my fresh application, dated 10th of December 2022. Serial number 2, head of the institution, forward to the DI with the resolution right hand side. And serial number 1, DI Malot sent to the West Bengal Central School Service.
It's on the ground of distance. For the commission and you have for the state. So distance ground application let it be decided by the commission. Every service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner made an application for transfer on general ground within bracket distance on 10th December 2022 on portal. Stop. After receipt of transfer application, school authority where petitioner is presently working forwarded the same to the concerned District Institute of Schools AC on 22nd November 2022.
22nd December.
On 22nd December 2022. Stop. On receipt of transfer application. On receipt of transfer application, District Institute of Schools processed the same and forwarded it through portal to the West Bengal Central School Service Commission on 3rd January 2023 for taking final decision. Stop. Grievance of the petitioner is transfer application of the petitioner is yet to be decided. Next paragraph. Respondents are represented by learned advocates who have submitted. Now, state respondents and West Bengal Board of Secondary Education. Now, state respondents and West Bengal Central School Service Commission are represented by learned advocates who have jointly submitted due to suspension of portal with effect from 29th September 2022. Contemporaneous decision could not be taken on transfer application of the petitioner. Stop. Next paragraph. However, it is submitted on behalf of commission if concerned authority is directed, transfer application of the petitioner can be decided in accordance with law. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing the.
Respondent number 2 is the chairman and 3 is the council and the commission itself.
You have not made secretary as party.
The commission itself is a party.
Directing the secretary West Bengal Central School Service Commission to decide the transfer application of the petitioner by 6 weeks from the date of communication of this order. Stop. Decision to be taken by the secretary of the commission shall be communicated to the petitioner by 10 days thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to decide transfer, shall not be a ground to reject the transfer application of the petitioner. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the cause title in course of this day and add Secretary West Bengal Central School Service Commission as additional respondent. Stop. However, service of notice upon additional respondent stands dispensed with since commission is represented by learned advocate.
Extremely good.
Next.
Amendment. Item number 13.
The petitioner.
Of the petitioner, she participated in the for admission in Jawahar Navodaya Vidyalaya, which is under the Ministry of Education, Government of India. She participated as the OBC candidate and she succeeded in the admission test.
For which class?
For class 6. But the admission has been denied due to pendency of the several litigations so far as the OBC candidates are concerned. But my lord, in the prospectus, it has been written the OBC candidates must be in the list of central category, central list.
As per the central list.
As per the central list. And the OBC, the petitioner belongs to OBC as per the central list also. So far as the litigations, these are regarding, my lord, the state list of OBC list. So, my lord, the respondent authority should not look into the litigations which pertains to the state list, my lord. If you lordship kindly have a look, my lord, the OBC certificate, my OBC certificate, which is at page page 17.
17.
17.
Yes. It is as per central list.
It is as per central list. Central list I have annexed, I am showing, man. Kindly see right hand side middle portion.
Just a minute. It's not an OBC A category candidate.
No, the subcategory is Chutor Mistri. Yes. Now, lordship kindly comes the central list which I have annexed at page 14.
Yes, you are which document?
Page 14, 1-4.
Yes.
On the left hand side, it has been written central list of OBC. Now, lordship kindly comes page 16. PL number 80.
80.
80.
Yes.
Muslim Chutor Mistri. So this subcategory is within the central list. So if the central list, if the OBC is there, my lord, this is not under challenge anywhere, my lord, and it pertains till date. So, my lord,
where is your result that you have been selected?
Yes, page
as OBC candidate.
Page 45, if you lordship kindly have a look.
Then what happened? You appeared before the principal.
Yes, on 23rd
June.
We
Yes.
appeared as
Then what happened?
Well, they are saying that so far as the OBC matters are concerned, these matters are under litigation. Unless the litigations are over,
allow him.
No,
Take
no,
admission.
he's not submitting the right thing. My lord. The question is, my lord, first of all, this petition is not happily drafted. This petitioner is the father of the student. He should have come as in a representative capacity. The petitioner has not been impeded in the writ petition.
Who
However,
has filed the writ petition?
father.
He is rightly done.
My lord, the
Where is the discrepancy in it?
discrepancy
Father should have come. Petitioner being minor.
in a representative capacity against the minor.
Yes, then where is the difficulty? in
My lord,
admitting
that
the,
the
son of the
difficulty is
petitioner?
what he is showing, my lord, that he belongs to the central list. It is not that, because, my lord, lordship kindly see, he was previously in the central list. My lord, subsequent.
Central list is page 14.
That list has
No, petitioner has not been identified as OBC A category candidate. So where is the difficulty?
difficulty is, my lord, he is
The
not.
petitioner is treated as OBC candidate, not OBC A. Then there is no
He-
difficulty.
He is not treated as.
Even during pendency of this issue, Supreme Court has said that directed the medical counseling authority to go ahead with the admission of medical admission.
The
So
question.
why petitioner will be penalized unnecessarily?
He is not in the central list. He is not in the central list. He has annexed the central list to mislead the court. The central list is this, and here the Chudor Mistri is not. And this has been cancelled.
Yes, please clarify.
Clarify. This is the central list in force now, and Lordship kindly see that the government of West Bengal recognize.
For the state of West Bengal. For the state of West Bengal.
And this central list has been is in vogue, Lord, because Lordship kindly see that this has been nullified.
Just a minute.
My Lord. With wide notification and this is the order of the 920.
Because central list which they are relying upon, school is relying upon the category which you belong to, that category is not in the central list.
No.
In the central list.
Yes, definitely.
For the state of West Bengal.
Yes.
Central list of OBCs for the state of West Bengal.
Yes.
Which I have annexed.
No, that is not
Annex
telling.
the old list. My Lord, this was there, but after this, my Lord, Lordship kindly see that by notification dated 2/6/2010, my Lord, this has been. Lord,
my list 63 onwards. By virtue of
Yes, Muslim Chudor Mistri is there.
Yeah, and that's why, my Lord, that has been cancelled by in terms of this order. 1929, Lordship kindly see.
1929.
Yes. And the state revised list is notification 1929 that has been cancelled by the Honorable Division. Bench order is there. That's
Now, Muslim Chudor Mistri was notified with a notification number 1929 BCW.
Yes.
Backward class welfare. MR Swanso dated 22nd June 2010. But it appears that by the judgment of the division bench dated 22nd May 2024.
Yes.
This memo number 1929 was set aside.
Yes. And
Now, my lord, kindly comes.
and then my lordship
The
kindly
executive orders classifying 42 classes made by the state being number so and so. Inter alia classifying 35 classes for reservation. Quashed with prospective effect.
yes.
Yes.
2010. Now lordship kindly now lordship kindly come to page 30. On this
Page?
page 30 of the writ petition. That is why, my lord, the SDO is writing that no OBC certificate has been issued in favor of Shabana Dhali, who intends to be admitted from this officiate. And that's why, my lord.
Just
no, my lord.
Yes.
That's why, my lord, page 26. This pro forma was given to the student for the guardian to fill up. So she could not because
Page 26.
yes, this is the pro forma of backward classes OBC. They filed a blank sheet because the district authority did not after this, my lord, did not agree to sign, and there is no such OBC list, OBC in the central list. That's why she failed to submit at the time of admission.
Yes.
Well, kindly comes page 15, 15. So the list, my lord, I have annexed.
This is the old list.
63 to 99. These subcategories were inserted by notification dated 17th February 2014.
Yes.
By the central government.
Yes.
And my lord, my learned senior friend is relying
No.
2000.
This it says that you belong to Chutor, Muslim Chutor.
Yes.
Mystery.
Muslim Chutor Mystery.
That prospective.
Now,
but from 2010 থেকে cancel হয়েছে। এটা 14 তে ঢুকিয়েছে তো?
Give a copy to this document to him.
Yes. I have already given to him. Yes.
Now, again, serial number 86, Muslim Chutor Mystery.
Yes.
Inserted video notification dated 1/2/29 BCW.
BCW means not
dated 2nd June 2010.
By the state of West Bengal.
That has been set aside.
By the state of West Bengal.
Yes.
Now, the central government also inserted by in 2014. Kindly consider this, my lord. The central
thing is same. Community is same.
Yes. Community is same.
Community is same.
But if
I could understand it if the community is different.
Yes.
Muslim Chutor Mystery.
But if some category has been
The
inserted,
Muslim Chutor Mystery has been categorized as OBC with a notification dated by the notification by BCW, and it is set aside by the division bench.
Right.
If Muslim Chutor Mystery is categorized by the central government by a different notification, and it is not set aside,
yes,
then but the effect is same. I could understand that you belong to a different category which is categorized as OBC by the central government, and the same has not been touched by the central government, by the Honorable High Court.
Yes. That is the only problem.
High Court division bench was
By the Honorable Division Bench, it has not been touched.
Yes.
It has been set aside.
No, Honorable High Court has set aside this notification of 2010 by the state government.
No, 1929.
Yes,
This
is by the state government.
Yes, the state.
But the category was inserted by the central. Kindly consider this, manner 2014.
At this stage, no interim order can be passed. If you want, the writ petition can be admitted.
And another thing, my lord,
subject to the final result to be taken by the Honorable
the direction of the Honorable Court, my lord,
because the judgment of the Honorable Division Bench has not been stayed by the Honorable Supreme Court, meaning thereby the judgment which is being relied upon by the school authority remains in force.
No, state
At the material point of time, that was not, the stay order was not granted.
Pursuant to the direction of the Honorable Division Bench, my lord, a new list was published by the state government. That was initially stayed. Honorable Supreme Court was pleased to stay the
stay order subsequently. That will not have any effect in your case.
Yes, because that was early.
Because you participated in the selection test or in the admission test
in 2024.
18 January 2025.
2025.
Yes, 25.
Before that, you filled a form.
Yes, I filled a
form. So
the
new classification made by the state government, which has been stayed by the Honorable Division Bench, and such order of the Honorable Division Bench has been stayed by the Supreme Court.
Yes.
Based on which, if you can make out a case, then court can consider it.
Yes. My lord, the new list, Chutor Mistry is there as OBC candidate. Now this list till date, my lord, pertains, holds in the field.
Where is that new list?
Well, that list, what I have.
In the central list, there is no such Chutor Mistry.
Bench order.
No, but you have to bring this all materials. Order of this court, order of the Supreme Court.
But I have.
And yes, come back.
Yes, I have.
And stay was granted much later because at the time.
But stay might have been granted much later.
Might
But in the new classification list, if Muslim Chutor Mistry has been classified as OBC,
yes.
and ultimately Supreme Court has stayed the order of the Honorable Division Bench, then court is bound by the order of the Supreme
No,
Court.
Lord, we normally followed at the time of admission. We are
and similar issue is it was considered by the Supreme Court in case of medical counseling, where Supreme Court has permitted counseling based on the order of based on the notification issued by the state government classifying afresh.
But in the new list of the central government, central list, this Chutor Mistry does not appear.
Matter relates to admission of the petition.
Already,
but not to fill up the vacancy.
But already 6 months gone, all seats are filled up.
How you can do this?
Because the session started in April.
Maybe.
And now we are in September.
You should not have done this.
Result was
My lord,
June.
my lord, he has filed this writ application now. By that time, the office seats are filled up. How we can accommodate, even if in April the session starts.
How can it be?
And
June
he has
result published.
how June result published?
No, not from April session starts. You are not saying the right thing. Petitioner was asked to appear before the principal on 23rd
Because
June
he was in
2025.
this. No,
Petitioner was asked to appear before the principal on 23rd June 2025. How April session starts?
My lordship, kindly hear me for a second. My lord, he was in the second list. He was selected in the second list, not in the first list. So the second list candidates, those who could not furnish the OBC certificate and other things, other requirements, my lord. So in place of them, my lord, few seats were to be intended to be filled up. Now the question is, my lord, it was in June this letter was issued on 14/6. But the session started.
If session started from which from
April.
So mid-session admission, how you
And
can
how
manage?
it is possible? My lord,
in a same school, I have passed an order.
Yes,
The mid-session admission is not.
two orders. I have got that order. My lord, I appeared on behalf of the Navodaya Vidyalaya.
I remember.
Yes. And
on 23rd June, we have been asked But if there would not have been any dispute regarding OBC, well, I would have got admitted in June or July.
But there
first week
was
of
a
July.
dispute.
Yes,
There was a dispute. Now the unnecessarily seat would have gone waste.
yes. 8 months gone.
If the seat is, it is not an employment, it is an admission. If another candidate is not permitted to take admission, then this seat would go waste.
Yes,
That is not correct.
I am
approach.
that I was going.
Now, today court is not in a position, you are praying for time.
Yes.
And the session if started from April 2026, what is the use of keeping a seat
Kindly
vacant?
give me short period
Short
of
is
time.
not possible. It will be posted after vacation.
Yes.
So therefore, what is the use of this keeping
And
the
all
seat
seats are
vacant?
filled up. And now he has come. He should have come earlier.
Keeping the seat, where is my fault, man? Kindly
Yes,
consider.
there is laches on the part of the petitioner.
Yes.
On 23rd June 2025, when you are not permitted to admit your word, then why you are filing this in August after 2 months?
Yes.
July, August. On the next date, you should have come to this court.
Yeah, my lord. Now there is no scope.
Unnecessarily, a seat should not go waste.
Yes.
Another student should get the
If all
opportunity.
seats are filled up, then I cannot say anything. If seat is
filled up,
vacant, my lord, one
Vice
seat.
principal is here.
No, I am not interested to see your vice principal
No.
since you are there.
No, my lord,
Now, if this seat should not go waste.
If the
Suppose if the decision is taken in the month of December, unnecessarily a seat would go waste. That is not permissible. That should not be the correct approach.
if the seat is available till date, my lord, one seat is there.
No. On instruction, they are saying
Yes,
that no
all
seat
seats
is
are
there.
filled up.
If you want, I can direct them. If court wants to satisfy its conscience, court can direct that to file an affidavit. By affidavit, they can say whether seat is.
No,
If seat is not there,
Let the matter be
if
decided.
if seat is not there, then entire thing is academic today.
Let the matter be decided. And if
Entire thing is academic because you are considering, court is considering admission of the word of the petitioner in class 6. If seat is filled up, nothing remains. You could have submitted a representation that you have been wrongly denied. When?
my lord, kindly see page 46. First August.
No date.
46, not 1st August, it was received, and 47, 2nd August.
And 11th August. Why this representation was not filed in the month of June?
Yes. Because to file this writ application, they filed it.
Why the representation was not filed in the month of June after attending the office of the principal on 23rd June? There should have been a representation on 24th June. July, August. Session started from April because you are not in the petitioner's word was not in the first list.
Yes.
Because there are certain seats which are lying vacant. That's why petitioner's case was considered.
Yes.
If all seats are filled up, then my lord, so far as the interim order is concerned, I should not say anything. But if I succeed in the writ petition, but I will pray one thing for next year, my lord.
Next
Admission
year.
should begin.
They will file an affidavit disclosing all these facts. Disclosing all these facts, file an affidavit. The court will consider this. Whether seats are lying vacant or not. When petitioner attended the office of the principal for admission of her daughter, and why petitioner was not permitted. Disclose this
in that event, my lord, my respectful submission is that let the school authority file a report in the form of affidavit.
No, not
in the
that.
form of
It's an
affidavit.
affidavit.
Yes, in the form of affidavit, they will file the report.
Yes. Matter is heard in filed or affidavit service filed on behalf of the petitioner.
On this count, my lord, lordship's order.
Matter is heard in presence of the learned advocates representing the petitioner and it's a Jawahar Navodaya Vidyalaya. Jawahar Navodaya Vidyalaya, page 45. South 24 Parganas. South 24 Parganas. Stop. Grievance of the petitioner is his daughter, after participating in the admission test conducted by the Central Board of Secondary Education, was selected for taking admission in class 6 in Jawahar Navodaya Vidyalaya, South 24 Parganas. Herein after referred to a state school. But no, state school, stop. Petitioner, being the guardian, was asked to attend the office of the principal on 23rd June 2025 for admitting his daughter, and accordingly petitioner attended the office of the principal. When daughter of the petitioner was denied admission, since denied admission, stop. Questioning denial of admission by the said school authority. Present writ petition is filed. Stop. Next paragraph. Learned advocate representing the said school authority submits petitioner submits, though daughter of the petitioner applied, though daughter of the petitioner applied for admission in class 6 under OBC category. As petitioner belongs to Muslim Chutor Mistri, quote unquote, which community was treated as OBC in terms of notification number 1929 hyphen BCW/MR sub capital /436 1929 hyphen BCW/MR hyphen 436/99 within bracket 1 close bracket dated 2nd June 2010. Stop. However, reliance is placed on the judgment of the Honorable Division Bench dated 22nd May 2024, whereby said notification date being number 129 BCW MR 436/99 dated 2nd June 2010 was quashed. সেন্টেন্সটা কি বলছিলাম? According to the state school authority, in view of the judgment of the Honorable Division Bench dated 22nd May 2024, passed on writ petitions, first one being WPO 60 of 2011, within bracket Amol Chandra Das versus the State of West Bengal and others. Petitioner ought not to be treated as OBC candidate, or petitioner's daughter ought not to be treated as OBC candidate. As a result whereof, daughter of the petitioner was not permitted to take admission. So in addition thereto, it is also submitted that seat is not lying vacant at present in class 6 to accommodate the petitioner since session started from April
25.
Another candidate was permitted to take admission in place of daughter of the petitioner. So, next paragraph. Having considered the submissions made on behalf of the parties, principal in charge of said school being respondent number 3 is directed to file an affidavit disclosing the reasons for not permitting the daughter of the petitioner to take admission in class 6 and whether seat is available in class 6 or not to accommodate the petition. Let such affidavit be filed by ten days from date. Stop. List the matter for further consideration, or by fortnight. By fortnight from date. Stop. List the matter for further consideration under the same heading on 28 October 2024. Try to find out other materials in order to buttress your case. And it also depends upon the decision to be taken by the Supreme Court. Issue is pending.
Your Lordship's order is also there, that in the mid-session.
That is different thing. But whether even if mid-session he has rightly submitted, for the next session petitioner can get a berth. The daughter of the petitioner.
Subject to the outcome of the Supreme Court.
Yes. She should be permitted to take admission in class 7. This court being the court of equity can pass such order.
But since she could not furnish the document,
that is not the for the next session she can take admission in class 7. Court is contemplating this. So file your affidavit. Yes.
Item number 15.
The statement. Yes.
June 2022, the petitioner was nominated as the president of the managing committee of the school. But that nomination documents, that memo was forwarded by the
June 2022.
Yes, the petitioner was nominated as the president of the managing committee by the government of West Bengal. But that memo was forwarded to the school authority. It was not communicated to the petitioner. But the school authority also did not disclose the such fact that
who is happening for the school authority.
But I saw that they have received.
School has to be heard.
Yes, I have served. They have received. The school as well as the new president.
How you have served upon the school? Show me.
Yes, my lord. By speed post, my lord, they have received it.
When?
My lord, I post it on
When school received it?
Yes, my school received on 18th August.
Yes. Now, petitioner has been nominated as the person interested in education.
No, president.
President.
President of
Where
the
is the
managing
nomination order? Page 19.
Yes, my lord.
It's not readable.
No, yes, the type copy is there. Page 16, my lord. 16A. Page 16 is the original copy. My lord, right type copy is page 16A.
22. Yes.
Yes. Like this was not disclosed by the school authority to the petitioner, and this memo was never communicated to the petitioner. Only in the year 2024, petitioner came to know, and immediately thereafter, school authority admitted their fault, and thereafter, by resolution, page 17, by a resolution dated, managing committee was formed, and petitioner was
inducted.
Took charge, yes, and took charge as the president.
Well, come back at 2. Before 2 p.m., I don't think it will be possible, but I will try to upload it in course of this day.
Prayer before the
Yes.
Pray.
My lord, may I be permitted to mention, my lord, my senior has mentioned this matter.
It is not a time to mention this any matter. Yes, please call the list. Oh, is it an original side matter? No. Call the original, mentioning for original side.
Mentioning for original side.
Call matters from appellate side lists.
Continuing item number 14.
Page 16, your lordship sees that petitioner was not nominated as the president of the managing committee. Now, on page 17, this was not disclosed, but only on 2024, this was disclosed for the first time, and thereafter petitioner assumed charge as the president of the managing committee. This is the resolution, page 17.
Page 17 is the
resolution. Where the petitioner assumed charge as the president of the managing committee. 17th September 2024.
Yes.
In terms of rule, the petitioner's tenure will continue up to 3 years from the assuming charge. In year 2025, my lord, the school education department nominated another person as the president of the managing committee. This is 19, and 19A is the type copy, my lord.
Where is that new nomination?
Yes, my lord. That is, page 19 is the copy, and the type copy is page 19A, my lord.
After expiring, comes to be as a comment.
That is under challenge. Yes, this newly nominated person will get chance when the new managing committee will be constituted. Not in the midst.
But count page 16, my lord, 16A once.
Yes.
The appointment can see. This is only for the 3 years. And next page, 16B kindly come. Copy forwarded.
If blindly this order is passed, then this discrepancy is certain.
But issued on, my lord, 20.
This discrepancy is imminent. It is bound to happen.
But it expiring
when the person nominated under order dated 8 June 2022 took charge as president. Answer the query of the court first. When the person nominated under as per order dated 8 June 2022 took charge as the president of the managing committee.
But managing committee 2 years in 2024, but we have
on 17 September
2024 managing committee is but my lord.
So therefore he has to function for a period of 3 years.
Yes, ma'am. But which is sub upon this. Can I see, my lord?
Yes, which is?
Can I see? Can come out page 16B? Copy forwarded to him directly, my lord. Serial number 6 to 12 sub directly. Come on, my lord. The 11, my lord. Copy forward. Kindly see.
Yes. What do you want to submit on that? Tell me.
My copy sub upon the petitioner.
So what? So what? How does it improve your case? Serving of copy.
Should have taken charge.
Demonstrate this. Explain
should
this.
Have taken charge in 2022.
How it is possible? Previously the managing committee was continuing under the presidency of another authority. That cannot, unless and until that committee's term expires, how the new managing president can take charge?
But he should appear
before
this authority, my lord.
Before
after getting the
order, before passing this order, the assistant secretary should have called the members of the managing committee.
True, my lord. That's true.
But
when
this new managing committee will be constituted or reconstituted.
That's true.
So considering the date of constitution, reconstitution, or the expiry of term of the managing committee, appropriate order should have been passed. If in the midst of the tenure of a managing committee, one person is nominated as a president, he has to wait till new managing committee is formed. I have found similar issue in Purulia district.
That's true,
and I had
but
to set aside the order of nomination.
But petitioner should have approached before the school of my lord.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. You have challenged this page 19.
Yes.
The government sponsored institution. Served on every service filed on behalf of the petitioner is taken on record. Who is the petitioner?
The president, who is the present president.
What president? President of the managing committee of.
It's an expert, my lord. Not the president, my lord. 14 July, the new.
Mongol Chandra Vidya, please take your seat. Don't disturb this court while dictating the order.
Sorry, my lord.
President of the managing committee of Mongol Chandra Vidyapith within bracket HS close bracket. South 24 Parganas has come up with the present petition questioning order dated 14 July 2025 issued by the Assistant Secretary to the Government of West Bengal, whereby one Ganesh Vishwas was nominated as the president of the managing committee of said school. ওখানে said school code করে দেবে, herein after refer to said school. Was nominated as the president of the managing committee of said school. Stop. Next paragraph. Learned advocate representing the petitioner submits. Petitioner was nominated as president of said school, president of managing committee of the said school. Vide order dated 8 June 2022 issued by the Assistant Secretary to the Government of West Bengal. Stop. However, after nominating the petitioner as president of the managing committee in the month of June 2022, however, month of June 2022, petitioner could not assume charge as the president of the managing committee, since tenure of the existing managing committee was not complete. Now, tenure of the existing managing committee did not expire. Stop. Stop. After expiry of the tenure of the existing, there was a previous managing committee. After expiry of the
That was expired, my lord.
after expiry of the previous managing committee, new managing committee took charge in the month of September 2024, when the present managing committee took charge.
Yes, madam. September 2024.
In the month of September 2024, and a managing committee and a resolution was adopted on 17 September 2024. Thereby, petitioner was inducted as president of the managing committee in terms of the order dated 8 June 2022. Stop. As the tenure of the present managing committee will expire, in the month of September 27, it is submitted that before expiry of the tenure of the present managing committee, impugned order dated 14 July 2025 may not be given effect. Next paragraph, state respondents are represented by learned advocate who has opposed the prayer of the petitioner and has made submission to defend the impugned order dated 14 July 2025 issued by the Assistant Secretary to the Government of West Bengal. Next paragraph. In terms of the rules for management, capital of, in terms of the rules for management of sponsored institutions, within bracket secondary close bracket comma 1972. Now, in terms of the relevant provisions of the rules for management of sponsored institutions within bracket secondary close bracket comma 1972, tenure of the managing committee, term of the managing committee is for 3 years, and the present managing committee of the said school took charge in the month of September 2024. Therefore, the present managing committee, therefore, term of the managing committee, therefore, life of the managing committee will expire in the month of September 2027. As per order dated 8 June 2022, petitioner was inducted as President of the Managing Committee of the said school. Vide resolution, Managing Committee resolution dated 17 September 2024. And the Managing Committee assumed charge in the month of September 2024. So therefore, it appears prior to September 2024, previous order dated 8 June 2022 could not be given effect to. As a result whereof, petitioner could not function as President of the Managing Committee prior to September 2024. Stop. Since petitioner has not been found to be disqualified to function as President of Managing Committee of a government-aided sponsored institution, based on order dated 8 June 2022, he should be permitted to function as the President of the Managing Committee till present Managing Committee till the expiry of the present managing committee. Stop. Next slide. Therefore, in terms of the order dated 14 July 2025, nominated person shall have opportunity to be inducted as President of the Managing Committee of the said school when Managing Committee will again be constituted in the year 2027 and not before that. Next slide. With the aforesaid observations and clarification, writ petition stands disposed of urgently. Next.
Item number 15.
Yes.
Matter related to the transfer.
For the state responded, Lordship.
Matter related to the transfer on distance ground, my lord. The petitioner applied for the transfer online and then reached out to the ACC man, pending before the ACC. But it is
Application for transfer on online application.
online application.
Where is the status of the application?
Page 22, my lord. And may I ready to supplementary affidavit, my lord. The page 22 is illegible, my lord. If your lord will
File it. Yes. Page 5. When you applied for?
Last year I applied on my lord, so that was August 2022.
Serial number. This is an application on distance ground. The school authority have already stated that 13 applications have been forwarded. Where forwarded? 13 applications in this ground and 4 on medical ground. Meaning thereby there were altogether 17 transfer applications which were forwarded, and 3 were transferred, 3 and 1 respectively. So perhaps you are not coming within the zone of 10%.
Forward, my lord. Since the application is pending before School Service Commission on general distance ground.
Let it be decided in accordance with law. Oh, it has been sent to the commission.
Yes, serial number 1.
School has forwarded it.
DI forwarded to the 26th of September 2020.
Yes. That I have not noticed. Right. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Supplementary, next paragraph, supplementary affidavit filed on behalf of the petitioner is also taken on record. Next paragraph. Petitioner made an application for transfer on general ground within bracket distance on 31st August 2021 on portal বলেছে তো? On portal, the sentence টা পড়ো। On portal on 31st August 2022, and same was forwarded by the school authority where petitioner is presently working to the concerned district inspector of schools within bracket AC. Stop. District inspector of schools AC processed the transfer application and forwarded the same to the West Bengal Central School Service Commission through portal on 26 September 2022. Stop. Grievance of the petitioner is transfer application of the petitioner is yet to be decided by the concerned authority of the West Bengal Central School Service Commission. Next paragraph, respondents are represented by learned advocates who have submitted perhaps a contemporaneous decision could not be taken on transfer application of the petitioner due to suspension of portal with effect from 29 September 2022. Stop. Next paragraph, learned advocate for the commission has submitted if concerned authority is directed, transfer application can be decided in accordance with law. Next paragraph. Having considered the submissions made on behalf of the parties, written petition stands disposed of, directing the whether the secretary is party.
No,
Directing the Secretary West Bengal Central School Service Commission to decide the transfer application of the petitioner by 6 weeks from the date of communication of this order. Stop. Decision to be taken by the secretary of the commission shall be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear the suspension of portal shall not be a ground to reject transfer application of the petitioner. Next paragraph. Learned advocate for the petitioner is granted leave to amend the cost title in course of this day and add secretary of West Bengal Central School Service Commission as additional respondent. Stop. However, service of notice upon additional respondent stands dispensed with since commission is represented by learned advocate. Urgent xerox certificate. Next.
Item number 16.
For the petition. In my lord, in this matter, we are appearing for the state.
Yes.
The petitioner retired from service on 28th February 2025. While the pension papers of the petitioner were being processed, he raised an objection saying that I did not.
When retired?
On 28th February 2025.
Yes.
And on 18th February.
From the post of teacher.
Assistant teacher.
18th February 2025, DPPG raised an objection, which is at page 38. Now, this is under challenge in this writ petition. The second paragraph, the teacher concerned did not acquire B.Ed degree within 5 years of her appointment on 3/10/2000. So, admissibility of the annual increment as allowed and continued on and from 1/10/2005 need to be reviewed and clarified in terms of GO number so and so dated 6th February 2018. Read with so and so.
Just a minute, teacher. If you did not obtain B.Ed degree prior to completion of 5 years.
It is something different. I was an organizing teacher. Pursuant to the direction of the Honorable Court, my approval was given in the year 2006. Lordship kindly comes page 23. And I obtained B.Ed degree within 5 years of 2006-2010. Page 23, my lord. Serial number 4 is the petitioner. Lipika Bose. An approval was given with effect from 1st October 2000. Not the second paragraph, last line. The following date petitioners are hereby accorded with effect from 1st February 2000.
Accorded with effect from 3rd October 2000.
Sorry, 3rd October 2000.
Yes.
And this memo was issued on 21st November 2006.
With retrospective effect.
With retrospective effect. I obtained my B.Ed degree in the year 2010.
This memo was issued on 21st November 2006. You obtained B.Ed degree?
In the year 2010. Within 5 years. Now, the authority, they are saying that since your appointment was approved with effect from 3rd October 2000, so you have to complete B.Ed degree 5 years from 2000.
But if that is not the correct stand of the authority, you are not entitled to get incremental benefits prior to before obtaining your qualification.
I did not get. Yes. After B.Ed degree, I got the increment.
When? From which date you got increment?
I got increment.
Because it is stated that appointed from 3rd October 2000. Very good. So, visibility of annual increment as allowed and continued on and from 1st of October 2005. So, it goes to show that you are allowed incremental benefit from 1st October 2005. How that is permissible?
Need to be
unless and until you are a trained teacher within a period of 5 years, you cannot get the benefit of increment. So, at best, from 1st of October, from 3rd October 2000, for a period of 4 years, you can enjoy increment. That is up to, because there is an retrospective effect. 2006 memo was issued granting approval from 3rd of October 2000. So from 3rd of October 2000 to 3rd of October 2004, 1, 2, 3, 4. 3rd of October 2004, you are entitled to get incremental benefits on fixation of your pay. But thereafter, since you are not having B.Ed qualification, which you obtained in 2010, so from 2004 to 2010, you are not entitled. After it will be stopped.
Provided I complete my B.Ed degree within 5 years. If I cannot,
you could not complete.
2006 approval was given. So date should be from 2006 up to 5 years. If I complete my B.Ed degree within 2011,
because you did not have the scope to from
I did
2000.
not have the scope to get the B.Ed degree, to get admission in any B.Ed college. Because
But if you are not a trained teacher, how you can get the incremental benefits?
the increment,
Incremental benefits is for training, which is to be acquired within a period of 5 years from the date of appointment.
Yes.
But admittedly, you are not a trained teacher.
I was not trained teacher.
So
But
if you are not a trained teacher, within the specified period to be
annual increment.
Annual increment is based on training.
Based on training.
Yes.
Provided I have to complete my training within 5 years. If I complete my training within 5 years, then my annual increment will continue. It will not stop. When it will stop, within 5 years I could not complete. After 5 years, it will stop. Then again I have to wait for 5 years. Then after 5 years, the increment will be. This is the rules, notifications basically says. From 2006, I have
A notification is that for within a period of 5 years, you have to be a trained teacher.
This is the notification.
If you are not trained, then up to
Not in
the extent of 4 years, you will get yearly increment. Then on the 5th year, it will be stopped till you attain qualification. After attaining the qualification or after acquiring the training qualification, from the date of acquiring, again you are eligible to get the yearly incremental benefits.
This is
stop. After completing total 10 years service,
For first 4 years, you will get.
I will get.
With retrospective effect from 3rd of September or with the 3rd of October 2010.
10.
No,
No,
3rd of
2000.
October 2000. So from 3rd of October 2000 to 3rd of October 2004, you will get for a period of 4 years.
4 years.
January 2001, 2002, 2003, 2004. After that, since you are not trained, it will be stopped. Then when you will acquire the training qualification since you acquired the training qualification in 2010, so from 2010 onwards, it will be revived.
But what is the scope of getting my B.Ed degree? From
What can be
2000
done?
to 2006?
Because this degree has to be based on your, this increment is based on your qualification.
But my lord, the approval was given in 2006. Unless
I
I am an
understand.
approved teacher, then I cannot get admission.
I
in any
understand, but if you are not trained teacher, how court can direct the authority to grant you the benefit?
But my lord, kindly consider the exceptional circumstance. It is not a general circumstance. The exceptional circumstance, approval has been given in 2006. Unless I am approved teacher, or I cannot get admission in any training college.
Yes.
If I approach for the authority prior to 2006, I would not have.
No, prior to that, you could have obtained training.
Prior to
That you could have
approval.
obtained training while you are discharged, functioning as an organizing teacher.
As
As an organizing
I
teacher.
could not, as in service candidate, I could not because my service was unapproved service.
Yes. Fresh candidate, you could have completed the B.Ed course.
But I was rendering service in the school as unapproved from 2000. As unapproved teacher, but I had to complete my B.Ed degree as in-service candidate. As the fresh candidate, I could not because I was appointed there. I was rendering service there, and the litigations were going on for approval of appointment. And I think, Madam, this is exceptional, Madam. And I have no fault, Madam. It's not a general issue, Madam.
Because there is a reason behind this. Because petitioner was an organizing teacher. Petitioner was appointed with a memo dated 21st November 2006 with retrospective effect from 3rd of October 2000. So in 2006, when petitioner got approval with effect from 3rd of October 2000, already 5 years passed. So where is the scope of obtaining qualification within obtaining training qualification within 5 years from the date of appointment?
But as per instruction, my lord, I got some instruction from the concerned authority,
I am
my lord.
asking you are the advocate of this court.
My lord,
Forget
prior
about
to
instruction. First,
okay,
you
my lord.
tell me that where was the scope so far petitioner is concerned to obtain qualification within 5 years? Because it is a it is a qualification, it is an approval with retrospective effect. So petitioner started obtained qualification in 2010. In 2010. So at least 5 years from 5 years from the date of approval memo dated 21st November 2006 should be provided to the petitioner. So if we add 5 years or if we count 5 years from 21st November 2006, so it will take up to 2011. Within that time, petitioner obtained qualification.
But as per
Yes, what is your instruction?
As per instruction, I am submitting before lordships. Because GO number such and such dated 6/2/2018. It is clearly stated, my lord. 348. May I hand over? Lord?
Yes, he has given 6 February 2018. Which part of this government order you are relying upon? Tell me.
After careful consideration of the first, second,
Yes, after
third.
read it.
Well, careful consideration of the matter, the governor is pleased to order that one-time relaxation granted by memo number 759-AC within bracket S /2P-1/09 dated 13/7/2009. Read with memo number 516-AC S/2P-1/09 dated 29/3/2000 may be extended in respect of increments for all untrained teachers appointed during the period from.
Petitioner is not claiming the benefit of this exemption. Petitioner is not claiming benefit of this exemption. What petitioner is saying that as a special circumstances, petitioner's time should have been counted from the date of approval of appointment. That is 2006. That is 21st November 2006, not prior to that. Think about the situation that the approval was granted on 21st November 2006 with a retrospective effect. So where is the scope left open to the petitioner to obtain qualification, training qualification within a stipulated period of 5 years if it is counted from 3rd of October 2000?
But in this
time expired.
In this
already time expired 3rd of October 2000. Count 5 years. 3rd of October 2000 means 2001, 2, 3, 4, 5. 3rd of October 2005, 5 years gone. And this memo was issued, approval memo was issued on 21st November 2006, when already 5 years was over. So as a special case, petitioner should be granted an opportunity to obtain qualification, training qualification within a next period, 5 years period from the date of issuance of approval memo.
In this regard, no any circular has been come from the concerned authority, my lord.
When you have obtained qualification?
Lord, I obtained qualification, my lord. Paragraph 3 I have stated.
Tell me the date.
My lord, 28th June 2010.
That is within 5 years from the date of approval memo. And where is the order of the court based on which approval was granted to you?
Yes, my lord. It
Being an organizing teacher?
Starts from page 25.
Petition.
operative portion, page 31, second paragraph.
এটা ক্লিন আছে, এটা ক্লিন আছে, তোমার কাছে এটা ক্লিন আছে, বোঝা যাচ্ছে না।
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph, petitioner. No, learned advocate for the petitioner submits that petitioner retired on superannuation on 28 February 2025 and till date has not received retirement dues including pension. A notice of this court has been drawn to a document at page 38 of the writ petition, wherefrom it appears an observation by the director of pension.
Yes.
Wherefrom it appears on behalf of it appears Directorate of Pension, Provident Fund and Group Insurance, while settling retirement dues of the petitioner raised objection.
May I say only one thing, my lord?
Objection that since petitioner was raised objection that since that petitioner was appointed on 3rd October 2000 as an approved teacher. Sanction of yearly increment from 1st October 2005 in favor of the petitioner requires review. Next one. It is contended on behalf of the petitioner that he or she was an organizing teacher of a school who was granted approval with a memo dated 21st November 2006 with effect from 3rd October 2000. Stop. Therefore, petitioner did not have opportunity to get herself trained within the span of 5 years if it is reckoned from 3rd October 2000. Next one. State respondents are represented by learned advocate who has opposed the prayer of the petitioner, and it is submitted that petitioner failed to obtain training qualification by 2nd October 2005. Therefore, till obtaining training qualification, she was not entitled to receive yearly increments. Stop. In reference to an order dated 6th February 2018, issued by the Joint Secretary to the Government of West Bengal, School Education Department, it is submitted that exemption was granted to the teachers relating to obtaining training qualification, but petitioner is not coming under the purview of said order dated 6th February 2018. 6th February 2018. Therefore, it is contended that there is no discrepancy in the objection raised on behalf of Directorate of Pension, Provident Fund and Group Insurance. Next paragraph. Petitioner was an organizing teacher who got approval of appointment in terms of the order of a coordinate bench dated 20 July 2006, passed on a writ petition being WP A615 of 2016. No, WPO 615 of 2006. 615 of WPO original side 615 of 2006 within bracket Shrimati Ila Shaha and others versus WBBSE and others close bracket. Pursuant to the order of the coordinate bench dated 20 July 2006, District Inspector of Schools AC Nadia, being respondent number 3, issued approval memo on 21st November 2006, thereby granting approval of appointment in favor of the petitioner being organizing teacher with retrospective effect from 3rd October 2000. Stop. Next paragraph. Now, stop. Stop. After obtaining approval of appointment, with a memo dated 21st November 2006, with effect from 3rd October 2000, petitioner obtained training qualification
On 28 June 2010.
Obtained training qualification on 28 June 2010. 28 June 2010, which is within a period of 5 years from the date of issuance of approval memo dated 21st November 2006. Stop. Next paragraph. This court finds substance in the submission made on behalf of the petitioner that she did not have opportunity to obtain training qualification within the prescribed period of 5 years if it is reckoned from 3rd October 2000. Taking note of the fact that approval memo was issued on 21st November 2006, thereby granting approval of appointment in favor of the petitioner on and from 3rd October 2006. Next paragraph. Under the specials, next paragraph. Under the aforesaid special circumstances, petitioner was required to obtain training qualification within a period of 5 years from the date of issuance of approval memo on 21st November 2006, and in the present case, petitioner obtained training qualification on 28 June 2010, which is well within 5 years. 28 June 2010, which is well within period of 5 years. Next paragraph, in view of aforesaid discussion, objection raised by the Directorate of Pension, Provident Fund and Group Insurance that petitioner was not entitled to get yearly increment from 1st October 2005 is not tenable. Stop. State respondents are directed to settle pension case, settle the pension case of the petitioner based on yearly increments granted to the petitioner. না সেন্টেন্সটা বলো of the petitioner, বাকিটা কেটে দাও, pension case of the petitioner taking into consideration yearly increments which was allowed to her from 3rd October from 3rd October 2000, or from when the first yearly increment was granted to you?
Second, next year, 3rd October 2001.
Now, taking into consideration the yearly increments granted to her, comma, within a period of 4 weeks from the date of communication of this order. Stop. State respondents are also directed to issue pension payment order in favor of the petitioner on compliance of necessary formalities and release retirement dues including pension at an early date but not later than 10 weeks from the date of communication of this order. Stop. Writ petition stands disposed of. Next.
Item number 17.
No short passover before vacation. If you time for time, I have to post it after vacation. At the time of call, accommodation is paid for on behalf of the petitioner. However, state respondents are represented by next paragraph lists the matter under the head option
practically
in the monthly combined list of November 2025. Next.
Item number 18.
I'm for the state pilot.
Extension of recommendation of primary teacher, my lord.
Who is for the commission? You are a commission, impaneled advocate of commission. Then same order is to be passed. Primary teacher working in primary school.
My lord, recommendation is valid. Where
is the recommendation?
My lord, recommendation
14 November 2014, 2024. 14 November 2024. Applied beyond 90 days.
beyond 90 days.
It must be in the month of April.
Yes, applied to 9.
Where is your application to the commission?
The commission. It's page 16.
Page 16.
17th.
Must be after 3rd of April.
90 days মধ্যে ইয়ে করতে সেন্ড হয়েছে যে 90 days এর মধ্যে করতে হয় 90 days এর পরেও বড় করে ডিভিশন তো স্কুলের নাম মজার নাম দেখো কারণ
এটা দেখে নেবে যেমন yes order passed not disposed of but disposed
তিনটে বেজে গেছে তাহলে আর হবে না
dismiss
Item number 201, list of appellate site.
I am for the petition.
In this matter, my lord, I am appearing for the respondent number 6, my lord. Headmistress of the school.
Against the word establishment of legal panel for the post of assistant headmistress.
Post of
Assistant headmistress. Just some take about the phone number 7 hearing, my lord.
who is appearing for the school authority.
I am appearing for the respondent number 6, headmistress of the school, my lord. After being filed the writ application, my lord, appointment letter has been given, my lord.
Subject to the
The
result of the
petitioner challenged, my lord, the approval of panel, my lord. Now, my lord, in terms of the approved panel, my lord, appointment has already been given.
my lord, can you see this. Subject to the result of the.
So where is the scope of interim order? There is no scope of any interim order.
It's co-entry model. Yes, sir. Because
Where is the illegality?
one man panel has been prepared. First of all, what can you see? This, the purpose.
Who are you?
I am the teachers. Two teachers here in Bharat who intend to find the.
Whether they participated in the selection process?
They could not because they were resist. I have mentioned in my report how this has been acted, Bharat. This one number 6, Bharat. What happened initially? There was a state mistake. She was.
I want to know first that why petitioners did not participate in the selection.
But I have mentioned in my petition that they were resisted, but they were resisted.
They were assisted or resisted.
Resisted.
They were resisted.
Yes.
And that's why they could not participate.
But they participated because during the COVID period, the school was closed. I have annexed those documents, my lord. The school remained closed, and they were subsequently they were called and put their signature. But
how they are resisted?
Yes.
I could understand if you could participate and then challenge. If you have not participated, where is your locus standi?
But we could not participate, but I have mentioned in my petition that how it was acted. But petitioner, but hearing the respondent number 7. Now he is appointed as assistant headmaster, headmistress. But what happened? There was a headmistress, but she was forced to resign from the headmistressship. And now this.
Don't tell me the history of the post of assistant headmistress or assistant headmaster. Tell me why you did not participate in the selection.
Can see now. The history is this. This number 7, my lord. What happened? She was appointed as teacher in charge.
If the petitioners are qualified teachers to
Yes,
be appointed,
qualified.
why they did not participate in the selection?
Because they were.
Where is the recruitment notification? Yes, I am asking you. Where is the recruitment notice?
But this is.
Yes.
Based on which application was invited? Applications were invited from the eligible teachers?
Page 28.
Page 28.
Yes. 8.
No, this is another. This is not that.
Where is the recruitment notification?
There is no. I have not. No. But if I'll come to page 26.
Just a minute. Where is the recruitment notification?
The page 26, Lord, Annex 5.
Page 26.
Contact check code.
No.
Can you see the date of the series of precedent? But 10th, notice dated.
Please wait.
Action 1480. So please.
Come to page 26.
Yes, 26.
See the names are at serial number 4 and 5.
Yes, ma'am. Yes, ma'am.
They signed.
Yes, I have marked.
They signed this notice.
Yes, they signed.
Yes.
They signed. Can you see the date?
Yes, 13 September.
No.
13 September and
Notice.
both are dated 13
Yes,
September.
I'm coming.
When the notification was, recruitment notice was issued on 11 September.
I'm coming. My dear Lordship, kindly see the date of notice. 11/9/2000.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioners are assistant teachers of Damdam Motijhil Girls High School within bracket HS Kolkata, who have questioned selection whether the selected candidate has been arrayed as a party.
Yes.
Respondent number 7.
Seven.
Who have questioned selection of respondent number 7 for the post of assistant headmistress in the said school. We open a hearing after referred to said school. Stop. It is submitted by the learned advocate for the petitioners that one-man panel was prepared, which was given effect to thereby appointing respondent number 7. Stop. It is also submitted that petitioners were prevented from applying for the post of assistant headmistress based on recruitment notification dated 11 September 2020. Recruitment notice dated 11 September 2021. Next paragraph. State respondents board, you are appealing board, state respondents, West Bengal Board of Secondary Education, and respondent number 6 are represented by learned advocates. Stop. Whether the approval has been granted, approval of appointment?
No.
Till date, no approval of appointment. But permitted to join the post. কি বলছিলাম Joint advocate representing respondent number 6 has placed before this court a memo dated 9th April 2025 and same is taken on record. Stop. On perusal of said memo dated 9th April 2025, it appears
for approval of which appointment. Finally, the appointment is in favor of
the panel prepared by the state school of
panel is approved appointment.
Panel is approved is known to me.
Appointment is approved.
Approval of appointment has been.
Yes, it's for my instruction, Lordship. DIC, Lordship. আরে কি নো 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 সেই দেখো আরে না বড় না
সাহেব কি দাও না রিপোর্টটা
কি স্বপ্না পাল has been approved by the district inspector while memorandum dated the meeting mentioned approval of his appointment.
No, panel is approved, not approval.
See the last paragraph, Lordship. Last paragraph.
But later shows that
Last paragraph. দেখি Srimati Swapna Pal, the only panel candidate joined the post AHM. Then Srimati Swapna Pal joined as the HM and the school authority submitted prior to the district inspector of the for approval of this appointment. Finally, the appointment AHM in February. Yes. Yes. By the district inspector. আমরাই জানো না কিছু তারা সেই চাকরি
কিন্তু রিপোর্টটা নিয়েছি রিপোর্ট আমার নেওয়ার কথা
it appears respondent number 7 was permitted to join to join the post of assistant headmaster, assistant headmistress, subject to result of the present writ petition. Since panel which was submitted by the said school authority was approved vide memo dated 31st January 2020. Next paragraph, Mr. Boisho Learned additional government pleader representing the state respondent submits that after joining the post of assistant headmaster, assistant headmistress, appointment of respondent number 7 was approved vide memo dated 10 July 2025.
Last lecture.
With the condition, memo dated 10 July 2025, subject to the result of this of the present writ petition. Stop. Next paragraph. On hearing the learned advocate representing the petitioners, it appears that they did not participate in the selection process. Stop. It was argued on behalf of the petitioners that they were not they were prevented from participating in the selection process by offering their candidature. But such submission is found to be not correct, as it appears from recruitment notice dated 11 September 2021 issued by the said school authority that both the petitioners signed on the recruitment notice on 13 September 2021 and their names are appearing against serial numbers 4 and 5. Stop. Next paragraph. Question would have been different if petitioners participated in the selection process being an eligible candidate. But in the present case, petitioners did not apply for the post of assistant headmistress. Therefore, stop. Therefore, petitioners do not have locus standi to question the selection process. Hence, the writ petition stands dismissed or then
What does this if terms?
Yes.
If you at that time, the school was
next matter.
Item number 202.
My candidature was rejected on the ground that at point of time I had no PhD. And thereafter, subsequently I have obtained the PhD degree.
Did it appear in the monthly list of December? because the issue is being considered by this court on other matters, whether the B.Ed qualification obtained after the cutoff date would be reckoned or not.
But this candidate is not the 10% para teacher candidate.
Who is the general category candidate?
This is- So, as far as that part is concerned, there are several judgments by my lord dismissing the petitions.
The earlier occasion, they also directed them to file a report.
Yes, report.
Report I missed it. I have not prepared. Let it be in the monthly list of December. I'll come back
No,
with the.
it's a different matter.
No, not for that purpose. Let it simply be adjourned.
Seven,
That's all.
7 days.
Very well done. I'll do it.
Yes. As paid for on behalf of West Bengal Central School Service Commission, time to file report in terms of the order dated 18th August 2025 stands extended for 10 days. Next paragraph, list the matter under the same heading for further consideration. Or list the matter under the same heading for further consideration in the monthly combined list of November 2025. Next.
Item number 203.
Yes.
By the Hassan issues conducted by the Arjo Samaj Association. The termination of the count of certificate of the BA, which was produced in the allegations.
The special schools run by special rules. Where is the special rule? Have you annexed the special rule? And why not? It's a disciplinary proceeding matter, and you have not annexed the special rules.
I have not annexed it. My or other mistake which also there. Case tonight explained before. Forwarded to me. But I find out that there was by mistaken.
Yes.
By mistaken, it could not be annexed.
To file a supplementary affidavit, annex it.
And other except the
Leave is granted to the petitioner to file a supplementary affidavit in order to disclose the rules, special rules, in order to disclose the special rules by which the DAV by which Dayanand Anglo-Vedic Higher Secondary School, Asansol, is governed. Let such supplementary affidavit be filed by 10 days from date.
Along with the inquiry report, which I
Stop. Where is your notice?
notice ko tayo.
School ke notice.
Yes, Mr. Badi, where is the notice? It's an old notice or new notice?
That is all.
Next paragraph. File affidavit service. Upore affidavit service filed on behalf of the petitioner is taken on record. Kore dao. Next paragraph koro. Right advocate for the petitioner is directed to serve notice upon non-appearing respondents or the learned advocates representing those respondents enclosing copy of this order by 10 days from date and file affidavit of service on the next date. List the matter under the same heading in the monthly combined list of November 2025. Next.
A supplementary affidavit is
10 days. File it.
your lordship granted leave to file a supplementary affidavit. Alright.
Supplementary leave লিখে দিত?
And annexing the special rule as well as the inquiry report. That inquiry report, that is our mistake, it was left out.
আচ্ছা তাহলে ওখানটা ঠিক করে দাও। এটা বলো। As well and the inquiry report.
Good.
And the inquiry report in connection with disciplinary proceeding and the inquiry report in connection with disciplinary proceeding initiated against the petitioner.
Good.
School has to be hard.
Other day they appear. After
And it is not on record, no order was passed. Next.
Item number 2.
The respondent.
I'm appearing on behalf of the petitioner.
My lord, before my learned friend starts, my lord, on last occasion, my lord, I have asked for a copy of this writ petition, my lord, since it is not with me, my lord.
Yes, what is the matter?
Lordship, the matter relates to the 3% additional increment of the headmaster of the upgraded higher secondary. 26 August, Your Lordship, a similar matter. Same way order may be passed.
Still petitioner is working. You are for the state.
Well, I have for the state, but I don't have the copy of a writ petition. Last occasion, I have asked for the same, my lord.
It was served upon the what can be done. How many occasions petitioner will go on serving copy? Disposed of. Serve a copy upon him. Next. Where is he? Where is he? He is sitting in chamber. No, give your names.
Item number 205.
Old service. The other side is not represented. That's why I am asking. What is the matter about?
Second item. Date of auction, 1 month.
Yes.
Date of change of option, 1 month.
Option for what?
Until DOPA, the date of fixation was made 1 month before, but that same will be changed after 1 month. I made an application before the director, I forwarded the change and the date back.
Who is appearing for the state? The state has to be heard in this matter, since you are taking the point of change of option, which was 1 month, which was delayed by 1 month. Mr. Boisho, appear in this matter, since you are in charge of this court. Issue. Affidavit is filed on behalf of the petitioner is taken on record. Next paragraph. In spite of repeated service of notice, state respondents are not represented. Next paragraph. Mr. Bhaskar Prasad Boisho, learned additional government pleader, is present in court, who is requested to represent the state respondents. Learned government pleader is requested to regularize engagement of Mr. Bhaskar Prasad Boisho on behalf of the state respondents, along with a junior of his choice. Next paragraph. A learned advocate for the state respondents is directed to obtain instruction in this matter. List the matter under the same heading in the monthly combined list of November 2025.
Retirement benefit, he has not.
Combined list, I am not updating.
I'm not asking for combined list. This is a matter which can be disposed of within a minute.
Yes, that I will dispose of when the appropriate time will come.
Whether this side,
No.
retirement dues.
No, sorry, Mr. Bari.
Item number 206.
I am trying to take up all the matters according to my limited English. Yes, yes. In other matters, this court has no sympathy.
Especially for retirement.
Yes, yes, yes.
Interesting.
There is an order.
item
Yes. Come back tomorrow. All the matter, interest matters. It okay. আপলোড করে দিয়েছো? পেয়ে যাবে এত।
Item number 1470.
My lord, I am for the
Who is for the state?
last occasion, my lord,
Your lordship directed to file supplementary affidavit annexing the first PPO.
File the notice.
Yes, my lord, I have filed.
Filing supplementary affidavit service.
Yes, my lord.
Oh.
Supplementary affidavit, my.
But there was no direction to file supplementary affidavit.
In another matter, my lord.
This is WPA 14809 of 2024.
Yes, my lord. Your lordship directed to serve the notice to the respondent.
Notice upon the learned advocate representing the state respondents, enclosing copy of this order by 7 days.
Yes, my lord.
There
I
is no
have,
direction for filing supplementary affidavit.
in another matter, my lord, your lordship
Matter,
directed.
I have not directed you to file any supplementary affidavit.
Because, my lord, in my petition, I have not annexed my first PPO. So, I file the supplementary affidavit annexing the first PPO.
Where is the notice which was served upon your learned upon your learned friend? File it. Now notice. Yes, assistant teacher.
Yes, my lord.
Retired on?
Retired on, my lord, 28th February 2017.
Revised, you are seeking interest on revised gratuity.
Yes, my lord.
First PPO?
First PPO on 2nd February 2017. Enacting by supplementary affidavit, my lord.
Revised PPO?
Revised PPO on 8th March 2022.
Issue. In terms of previous order, notice was served upon the learned advocate. In terms of the previous order, notice served upon the learned advocate representing the state respondents. Or in terms of previous order, notice served upon the learned advocate for the state respondents is filed today and same is taken on record. Stop. One supplementary affidavit is also filed on behalf of the petitioner and same is taken on record. Next paragraph. Assistant teacher, revised PPO, 14th February 2020, state respondents is present. Please post it. Apna naam ta jano.
Item number 1471.
My lord, I am for the petition.
Assistant teacher.
Yes, my lord.
Retired on 31st December 2017.
Yes, my lord.
First PPO 27th April 2018.
My lord.
Revised PPO
13th July 2021.
একটা চেঞ্জ হবে করে দাও in terms of previous order supplementary affidavit is filed today on behalf of the petitioner and same is taken on হলো তারপর next paragraph করে assistant teacher ওই revised PPO 14th February 2020 state respondents are represented disposed of. Next.
Item number 1472.
My lord, I am for the petition.
Yes. Assistant teacher.
Oh, my lord, clerk.
Clerk. Supplementary affidavit you are filing.
Yes.
Retired on
31st August 2016.
First PPO
31st January 2017.
revised PPO
11th August 2021.
tomorrow in terms of previous order, supplementary affidavit is filed on behalf of the petitioner and same is taken on record. Revised PPO clerk.
Yes, Madam.
State is represented, disposed of.
Item number 1473.
31st January 2022, my lord. Order should be approved, my lord.
Who is for the state? Affidavit service issue. In spite of affidavit of service filed on behalf of the petitioner is taken on record. In spite of Devan. Affidavit service filed on taken on record. So in spite of service of notice, state respondents are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 10 days from date. Stop. List the matter under the same heading in the monthly combined list of November.
Kindly allow me one minute the supplementary because disbursement did not the disbursement not annexed.
Leave is also granted to the leave is also granted to the petitioner to file supplementary affidavit disclosing the date of releasing benefits in favor of the disclosing date of releasing literal benefits to the petitioner. Next.
Order sheet ta khule এসছে, order sheet.
Item number 1474.
Supplementary affidavit annexing the first PPO.
Have you served the supplementary affidavit upon the state?
Sir, I took attempt, but she is unable during weeks admitted. During 3 weeks, he admitted in hospital. Also, previous day also I took attempt. Her husband reported me she is very ill. Now he is admitted in SSKM. Previously on in Lordship James Kolani, thereafter now he is
When petitioner retired?
assistant teacher.
Assistant teacher. Retired on?
Retired on 30th November 2016. First
30th November 2016. First PPO dated?
9th November 2016.
Revised PPO?
Revised 27th May 2021.
Issue. In terms of previous order, supplementary affidavit is filed or in terms of the order dated 13th August 2025, Supplementary affidavit is filed on behalf of the petitioner and same is taken. Stop. Though notices were served upon the learned advocate representing the state respondents, but today's state respondents are not represented. Next paragraph. The assistant teacher, revised PPO, assistant teacher, first PPO, revised PPO, retired on 30th November 26. On 14th February 2020. Next.
Item number 1475.
Sub notice. Yes. Petitioner was?
Petitioner is the assistant teacher.
Retired on?
2019.
First PPO?
24th January 2009.
Revised PPO?
12th August 2000.
In terms of previous order, notice was served upon the learned advocate for the state respondents and same is taken on record. Next paragraph, in spite of service of notice, state respondents are not represented. Next paragraph. Assistant teacher, revised PPO. 14th February 2020. Next.
Petitioner.
Item number 1476.
Yes. Have you served notice?
Yes, but his phone is not reachable.
Yes. As a petitioner was?
Harness.
Died in harness.
Husband.
Who is the petitioner? Husband or wife?
A wife. Husband is the petitioner.
Husband is the petitioner. Wife retired on? No, died in harness. Question of retired does not arise. Just in on
28th October 2020.
28 October 2020.
2020.
28 October 2020. Single PPO.
PPO issued on 1st December 2000.
Issue. Joint advocate representing the petitioner submits that in spite of making attempt to serve notice upon the learned advocate representing the state respondents, notice could not be, notice could not be served as the learned advocate was not available. Next paragraph. Husband no. Next paragraph. Wife of the petitioner Wife of the petitioner, assistant teacher. Wife of the petitioner was assistant teacher who died in harness on 28 October 2020. After date of husband of the after death of wife of the petitioner, pension payment order was issued on 1st December 2021. Thereby releasing terminal benefits, including death gratuity, in favor of the petitioner. Petitioner prays for release of interest due to delayed payment of gratuity. Next paragraph, so and so directed to release from the date following the date of death of the wife of the petitioner till the date of release of gratuity. Disposed of.
Item number 1477.
For the state.
No, not in this matter. Disposed.
Yes.
Died in harness.
Who has come? Wife or husband?
Daughter. Mother of the petitioner was assistant teacher.
Show me the legal age certificate. In case of spouse, there is a nomination. But if successors come, then you have to show the legal age certificate. Because there are other legal heirs. If ultimately subsequently they lay claim or they make claim, there will be the authority will find it difficult. Yes. How it will be improved on the next day?
I will take instruction.
You have to produce legal age certificate. Issue. In terms of previous order, notice was served upon the learned advocate representing the petitioner, and same is taken on record. Stop. Next paragraph. On hearing the learned advocate representing the petitioner, it appears that petitioner is daughter of a deceased teacher. Petitioner is daughter of a deceased teacher who prays for payment of interest due to delayed payment of gratuity. As mother of the petitioner died in harness. So, in next paragraph, in order to substantiate claim of the petitioner, this court finds legal age certificate is necessary. Next paragraph, learned advocate for the petitioner has prayed for accommodation to obtain instruction whether petitioner has obtained legal age certificate or not. Next paragraph. List the matter under the same heading in the monthly combined list of November 2025 for further consideration.
Item number 1478.
Yes, petitioner was a teacher or who has come? Husband died in harness. Died in harness. Died in harness. Died on
January 2002.
10. And today his wife is coming. Very vigilant petitioner. After 23 years, she is coming. When husband died,
January 2002.
January 2002. Yes, sir. In terms of previous order, notice was served upon the learned advocate representing the state respondents. Now, notice was served upon the learned advocate for the state respondents and same is taken on record. Stop. In spite of service of notice, next paragraph, in spite of service of notice, state respondents are not represented. Stop. Wife of a husband was a teacher. Wife of a retired teacher who died on 12 January 2002. Who died in harness on 12 January 2002. Has claimed interest due to delayed payment of gratuity. Next paragraph. On the pension payment order, now on perusal of pension payment order, it appears after death of the husband on 12 January 2002, state pension payment order was issued on 28 December 2004 and writ petition is filed precisely after 20 years, claiming interest on gratuity. Next paragraph. There is no plausible explanation of delay. Next paragraph. Writ petition needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks after ensuing puja petition. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Learned advocate for the petitioner is directed to communicate this order to the respondents by 7 days from date and file further affidavit of service on the next day. Next.
Item number 1479.
Worship, I'm appealing for the state in this matter.
First PPO.
Petitioner was headmaster. Retired on
January 2020.
31st January 2020. First PPO
3rd February 2020.
revised PPO
22nd February 2021. 26th February.
26th February 21. In terms of previous order, notice served upon the learned advocate for the state respondent is filed today and same is taken on record. তারপরে ওই headmaster revised PPO state respondent is represented by learned advocate who appears on virtual mode. Returned on 31st January, this prior to 14th February. From 14th February 2020, 8% disposed of.
Deeply object, Your Lordship.
Item number 1480.
Notice was not served because my lord, his phone is not reachable.
Yes.
Notice was not served, my lord, because phone is not reachable. His phone. Tied in harness, man.
Make another attempt. 1st September 2025 notice. Order was passed on 20th August 2025. Learned advocate representing the petitioner is granted. Learned advocate for the petitioner prays for extension of time to file to serve notice upon the learned advocate representing the state respondents. In terms of order dated 20 August 2025. Next paragraph. Hearing of this matter stands adjourned. And advocate for the petitioner is dated to serve notice by 10 days from date. List the matter under the same heading in the monthly combined list of November. Take it back. Next.
Item number 1481.
Notice served.
Yes, sir. Revised PPO, my lord. Petitioner is the my lord clerk.
Clerk. Retired on
31st March 2018.
revised PPO.
Revised PPO, my lord.
Past PPO
15 March 2018.
revised PPO.
Revised PPO, my lord, 12 November 2021.
In terms of previous order, notice served upon the learned advocate for the state respondents is filed in court and same is taken on record. তারপরে clerk revised PPO. In spite of service of notice, state respondents are not represented. তারপরে clerk revised PPO. From 14th February 2020 till date of release. 8% discount. Next.
Notice order upore. Item number 1482.
I tried to serve second time, but the phone number was out of service.
Yes.
Petitioner was assistant teacher.
Petitioner was
Assistant teacher.
retired on
30 June 2016.
June 2016.
Yes.
First PPO
2016.
June 2016. Revised PPO
24th March 2022.
Why notice could not be served?
Phone was not available.
Such a
At many times.
In which bar the advocate sits?
I got the number from the
Aditya Dotto, are you aware of?
number was given from the office lordship. I tried. The number was out of service.
Issue. Lawyer advocate representing the petitioner submits. Attempt was made to serve notice upon the lawyer advocate representing the state respondents, but he was not available. Stop. Next paragraph. Assistant teacher revised PPO. 14 February 2020 disposed of. No.
Item number 1483.
And for that.
Yes.
Single people, librarian.
In a school.
Yes, sir.
Retired on
July 2016.
PPO
2nd August 2017.
here for the state. In terms of previous order, notice was served upon the lawyer advocate for the state and same is taken on record. Librarian, single PPO, state respondent is represented from the date following the date of retirement till the date of release. 8% disposed of. Next.
Notice to order. Item number 1484.
Not served because the learned advocate was saying he was not well and I never tried to serve him, but he is not coming to the court. Every time I called him.
Where is your notice?
Vikas Kumar Mukherjee.
You are a state panel advocate. No, I'm asking you. Yeah, I will not pass order. I will direct him to take instruction. What is your name? Subhadip Moitru, state panel advocate. Land advocate representing the petitioner submits that notice could not be served upon the land advocate for the state respondents in spite of making attempt. Next paragraph. Mr. Subhadip Moitru, land advocate, is present in court, who usually represents state respondents. Land government period is requested to regularize engagement of Mr. Subhadip Moitru, land advocate, on behalf of the state respondents. Next paragraph. Land advocate for the petitioner is directed to serve copy of the writ petition upon Mr. Subhadip Moitru, land advocate, by September 2025. Next paragraph. Land advocate for the petitioner, land advocate for the state is directed to obtain instructions. Next paragraph. List the matter under the same heading in the monthly combined list of November 2020. Take it back.
Item number 1485.
I'm for the petitioner, my lord. Interest of gratuity, single BPO.
Petitioner was
Assistant teacher, my lord.
when retired?
Retired, my lord, 31st October 2020.
First PPO.
My lord, 15th December 2021.
Assistant teacher. Single PPO. That's good. No, first time. Okay. Where is the notice? Yes, state is represented. Where is your notice?
I went to my lord GP office, my lord, is GP.
Why you have not served notice? If state would not have been represented today? State respondents are represented. মাঝখানে যেটা given. Disposed of. Next.
Item number 1486.
Yes, which for the petitioner.
Try to serve the notice or should
He is appearing for the state. Yes.
retired from 30 June 2019.
Single PPO. 30th June 19.
Yes.
First PPO.
3rd September 2019.
September 19. Revised PPO.
30th March 2021.
Vishwakam. In terms of previous order, matter is taken up for consideration. Other side assistant teacher, revised PPO, 14th February 2020, state is represented. Disposal. Next.
Item number 1487.
But I am for the petitioner. Serve notice in terms of earlier order.
Don't give others' name. Give your name in the before on behalf of the petitioner. I deprecate this practice. Last occasion I noticed this while signing the orders where you appeared.
I'm sorry.
Yes.
It's not for remember. Okay. Yes. I'm remember my name.
I remember everything.
There was my lord.
Yes.
The Urkita Saha.
Don't give others' name. You are appearing, give your name on behalf of the. Yes.
My lord, the petitioner was a non-teaching staff clerk, my lord, in this matter.
Clerk retired on
30th November 2016, my lord.
Have you served notice?
My lord, I have served.
Whether acknowledgement was given by the clerk of the petitioner, advocate, or your clerk?
No.
Nothing is readable regarding that acknowledgement.
Received. I have seen they are received.
Yes.
30th November 2016, he retired.
30th November 2016.
Man.
First PPO.
First PPO issued on 6th September 2016.
Revised PPO.
7th June 2020.
7 June, it is not readable. 7 June
2021.
7 June 2021.
My lord.
The notice issue in terms of previous order. Notice was served upon the learned advocate for the state respondent and same is taken on record. So, in spite of next paragraph, in spite of service of notice, state respondents are not represented. Next paragraph, with clerk, revised PPO, 14th February. Right. Disposed of.
Item number 1488.
Yes. Yes. Retired on
It was January 2017.
first PPO.
But January 2007.
Third January 2017. Revised PPO.
23rd March 2020.
Notice is filed in spite of service of notice. State respondents are not represented. Assistant teacher revised PPO. 14th February 2020. Disposed of. This time.
Item number 1489.
Yes. Retired on
30th April 2008.
single PPO. Date
2008.
Assistant teacher single PPO, notice filed, state not represented. Disposed of.
Item number 1490.
Yes. Retired on
January 2011.
31st January 2020. Past PPO,
5th April 2020.
revised PPO,
27th July.
same order, notice filed, state not represented, assistant teacher, 14th February 2020. Next.
Register. Item number 1491.
I'm attending for the petitioner matter.
Yes.
If when attempt was made, my lord, is what traceable one?
Not traceable.
Yes, my friend, please switch this phone now. No part number, no address, nothing, my lord.
What you are praying for?
Paying for? Revise 50 or get my interest on gratuity. Revise 50.
Yes, petitioner was working as
Headmaster.
retired on
30th 11 2019.
past PPO,
17th 11 2019.
27/11/2019.
Yes, madam.
Don't say 11 before the code. Say 27 November 2019, not 17.
27 November 19.
Revised PPO,
8th November 2020.
is okay. Client advocate representing the petitioner submits in terms of previous order. Notice was attempted to be served upon the client advocate representing the state respondent, but the client advocate was not available. Next paragraph. ওই করে দেবে headmaster revised PPO. Disposed of. Next matter.
Item number 1492.
14? Already order is passed, sorry. Yes. Yes.
Non-teaching group D staff.
Notice.
Notice server.
Group D.
Yes, sir. On
Retired on
31st March 2016.
revised PPO.
Revised.
Past PPO.
14th March 2016.
Revised PPO.
11th July 2020.
Notice served, taken on record, state respondent is not represented, group D.
Notice.
Item number 1493.
Matter notice has not served, Lordship.
Record an order at the time of call, learned advocate representing the petitioner prays for extension of time to file notice or to serve notice, prays for extension of time to serve notice in terms of order dated 20 August 2025. Stop. Hearing of this matter stands urgent. List the matter under the same heading in the monthly combined list of November 2025. Now, next.
Item number 1494.
You are for the state. Yes. Where is your notice? Revised PPO.
Revised.
Petitioner was?
Widow.
Wife is coming.
Wife is coming.
Husband died in harness or died after return. Then wife is the petitioner. Husband was?
Assistant headmaster.
Husband retired on?
31st December 2017.
First PPO?
15 December 27.
When husband died, after the revised PPO or after, at which stage?
After revised PPO or
husband died. Very well. First PPO?
15 December 2017.
Revised PPO?
5th March 2021.
Date of death?
17 October 2023.
Issue. In terms of previous order, notice is filed and notice served upon the learned advocate for the state respondents is filed today and same is taken on board. Next paragraph. Wife, husband of the petitioner was an assistant teacher who retired on superannuation on 31st December.
Assistant headmaster. Right?
Assistant headmaster, right. Assistant headmaster who retired on superannuation on 31st December 2017. Stop. After superannuation of husband of the petitioner, first pension payment order was issued, and thereby releasing due to revision of pay as per ROPA 2019, revised pension payment order was issued on 5th March 2021, thereby releasing revised benefits including gratuity. Subsequently, husband of the petitioner died on 17th October 2023. Stop. Petitioner prays for release of interest due to delayed payment of revised gratuity. Stop. State respondents are represented by learned advocate. Next paragraph. Eki hobe from 14th February 2020 till the date of release. যেহেতু রিটায়ারমেন্টের পরে মারা গেছে।
Order of item number 1495.
Earlier occasion was a direction upon the state to seek instruction.
Not a usual matter.
Yes, my lord, because there was a conversion. He was initially CPF, thereafter as per court order, my lord, he was come under the pension scheme. At that point of time, he did not ask for interest. Now he is claiming for interest over arrear pension. And another issue, my lord, here he also make a prayer for interest on gratuity. That is also equal to.
Now this conversion was made by.
As per court order.
As per court's.
Kindly consider the.
Beyond the time stipulated in 13 June 2014 notification.
Conversion taken place, but he has made a prayer that it should be from the date of retirement. That is the challenge he has. That is the first round of litigation he has filed. In that particular application, he has made the prayer for releasing the arrear pension, but without making any prayer for interest. That is the first round of litigation, and in that particular petition, my lord, the court has directed that it should be from the date of retirement. My lord,
Date of retirement what?
date of retirement of the petitioner, my lord, pension should be effected from the date of retirement on conversion. Date of retirement of the petitioner. In that petition, he has not made a prayer for arrear pension, my lord, interest on arrear pension. Only seeking make a prayer for, my lord, kindly release my arrear pension from the date of retirement on conversion. Conversion already effected. Now here,
When conversion was allowed
my lord,
from CPF to GPF?
my lord, if I will consider the order, page 56.
Now, in terms of this order dated 26th April 2024, petitioner was an assistant teacher.
Yes.
He was allowed to switch over from CPF to GPF.
CPF.
Now, thereafter, pension payment order was issued. Now, petitioner is praying for interest on gratuity and arrear pension.
Interest on gratuity and arrear pension. Though in one of the writ petition, he had made a prayer that my pension should
But
be.
where is the delay? If this order was passed on 26th April 2024,
Yes.
and where is the pension payment order?
My lord, on conversion, pension payment order perhaps has not been annexed. My lord, I received the instruction that, my lord, PPO was issued on 29th of April 2015.
29th April 2015.
That is it. Can you consider page 29?
29th April 2015.
Yes.
It's a previous PPO, perhaps.
My lord, here
After the order was passed on 26th April 24, when the PP was issued.
Because it was a case where already PPO was issued in his favor, my lord, affecting pension.
That is under CPA.
Yes, for date affecting the pension, my lord, from the date of refund. There he had made a prayer that it should be from the date of retirement. That court has allowed. But in this writ petition, he has not made a prayer for interest on arrear pension. So that
this order, by this order dated 26th April 2024,
yes,
petitioner was permitted to obtain pension from the date of retirement.
Now, my lord, in that writ petition, that writ petition is also annexed. But in this writ petition, he has not made a prayer for my lord, interest on arrear pension. So that ground is
now this arrear was allowed in favor of the petitioner from the date following the date of superannuation till the date of refund. Now, so therefore, the first pension payment order was 29th April 2015.
Yes, but here
that is after conversion. They'll come back on the next day.